Once again, we would like to thank our sponsors for the lecture today, Rex Bookstore and Central Books. And it is with honor now to introduce to you our lecturer for today in property persons and successions, Dean Nenita Dela Cruz-Tuazon. So, Dean Nenita Dela Cruz-Tuazon is presently the Executive Director of Legal Services and Dean of the College of Law of Bulacan State University in Malolos City, Bulacan. She teaches civil law review, conflicts of law, corporation law, persons and family relations, trial technique, and legal research and thesis writing. She is also a mandatory continuing legal education lecturer for lawyers and bar lecture reviewer for law students and bar examiners. She is also an active law practitioner in the field of litigation and holds corporate works in various companies. She also served as hearing officer at the National Water Resources Board, a former municipal administrator of Municipality of Bukawi, Bulacan, and a public attorney in the Public Attorney's Office. She is a graduate of Doctor of Civil Laws, cum laude, and Masters of Laws from the University of Santo Tomas, where she now teaches civil law, reforms, and intellectual property law in its Graduate School of Law, and sits as panel in dissertation thesis defense. She finished her law degree from Arellano University School of Law and holds a bachelor's degree in commerce, major in accounting from the University of Santo Tomas, where she is a college awardee. She also graduated as honorable mention and valedictorian during her secondary and primary studies respectively. She is a member of Integrated Bar of the Philippines, Bulacan Chapter, and Kababaihang Manananggol ng Bulacan or KMB, and a former Vice President of UST Graduate School of Law, where she also sits as a faculty council member. Let us all welcome our lecturer for today for Property Persons and Succession, Dean Nenita Dela Cruz-Tuazon. Dean?
Thank you, Cheryl, and a pleasant afternoon sa lahat ng ating mga taga-subaybay. At this is really an honor on my part to share with our barristers lectures on persons and family relations, property, as well as wills and succession. So I hope that everybody is fine and in perfect health and ready to listen.
Okay. Should we start na po, Dean?
Yes.
Thank you po.
Okay. So we'll start our lecture on persons and family relations. We start with when law takes effect. Doctrine. Is publication dispensable? Publication, as we know, is indispensable as a general rule. But the legislature may, in its discretion, provide that the usual 15-day period shall be shortened or extended, as what was held in the case of Umali versus Estanislao. So the publication must be in full or it is no publication at all, since its purpose is to inform the public of the contents of the law. So as a general rule again, all laws are required to be published in full. By way of exceptions to the publication requirement, we have those issuances which are not required to be published, such as municipal ordinances, which is governed by the local government code. We have the rules and regulations, which are internal in nature. That's the reason why they are not required to be published anymore, because they regulate only the personnel of the administrative agency and not the public. What else? Letters of instruction issued by administrative supervisors. Again, it involves internal rules and guidelines to be followed by their subordinates in the performance of their duties. And also interpretative regulations regulating only the personnel of administrative agency. By way of exception to the exceptions, meaning these are administrative rules and regulations which require publication. Because as we said earlier, when it comes to administrative rules and regulations, we don't have to. But these instances, when these administrative rules has as purpose to implement or enforce existing laws pursuant to a valid delegation, requires publication. What else? If the administrative rules is penal in nature, and also when it diminishes existing rights of certain individuals. So we have this case of DENR, Employees Union, versus Secretary Florencio Abad, which is an en banc decision on January 19, 2021. In this case, what was resolved is whether or not publication is indispensable in the issuance of DBM Budget Circular number 2011-5. Why? Because in this case, the petitioner, DENR Employees Union, assailed the constitutionality of this DBM Budget Circular number 2011-15. Why? Because it placed 25,000 ceiling on the amount of the collective negotiation agreement, no, incentive for 2011. And as a consequence of which, COA disallowed the DENR's issuances of CNA incentives to its employees, to its officers, to return the excess. So natural, these employees, no, in the persons of this DENR employees union, would object because they are required now to return the excess. They claim that in view of the circular's lack of prior publication in the official gazette or newspaper of general circulation required by law, and jurisprudence of administrative regulations as a condition for their effectivity, it failed to comply with what is required by law. According to Secretary Abad, in contesting or by way of counter allegations, he claimed that publication was already complied when he notified, no, when there was a notice sent to DNR employees. So, in resolving now this issue, the Supreme Court said that indeed, in this case, publication is indispensable in the issuance of DBM Budget Circular number 11, 2011-5. Accordingly, as what was held in a string of decided cases by the Supreme Court and was also taken up in this case, an administrative regulation can be construed as simply interpretative or internal in nature, dispensing with the requirement of publication when its applicability needs nothing further than its bare issuance, for it gives no real consequence more than what the law itself had already prescribed. But when this administrative rule goes beyond merely providing for the means that can facilitate or render least cumbersome the implementation of the law, but substantially increases the burden of those governed, then it behooves the agency to accord at least to those directly affected a chance to be heard. Because according to the highest court, in this case, while the assailed DBM Budget Circular number 2011-5, dated December 2011, was in fact published in the Philippine Star, because that was also the contention of Secretary Abad, it was done only belatedly It was only on February 2012, or 2 months already after the issuance of the same, which was the date when this was published. So the circular also was not filed before the UP Law Center owner as required and as mandated by the Administrative Code of 1987. All right, we proceed now with the ignorance of the law doctrine. Okay? So, what is the presumption? The presumption is that we have knowledge of laws. That is the presumption. Everyone is conclusively presumed to know the law. Hence, ignorance of the law excuses no one from compliance therewith. Article 3 is very clear on that. This conclusive presumption presupposes that the law has been published. Without such notice, without such publication, then there would be no basis for the application of this maxim ignorantia legis non excusat. But by way of exceptions, we have this mistake upon a doubtful or difficult question of law, which may be the basis of good faith. What else? Under Article 2155, payment by reason of a mistake in the construction or application of a doubtful or difficult question of law that may come within the scope of this article, which is also another exception to this presumption. What else? In order that fraud may make a contract voidable, Article 1344 is instructive that it should be serious, should not have been employed by both contracting parties. So incidental fraud only obliges the person employing it to pay damages, which is also one of the exceptions to this presumption. As we all know, it covers your knowledge, the presumption of knowledge in law covers all Philippine laws. But it is it cannot be applied to foreign laws because again, the ignorance of a foreign law is a mistake of fact. There is no presumption of knowledge of foreign laws. It must be alleged and proved as a matter of fact. Otherwise, the doctrine of processual presumption will apply. So, clearly, the laws referred to under Article 3 of the Civil Code are those of the Philippine laws. So it applies to all kinds of domestic laws as we mentioned earlier, whether civil or penal, substantive or remedial. However, the article is limited only to mandatory and prohibitory laws. It does not include those which are merely permissive. And again, it is not applicable to foreign laws. Let's proceed now to a common doctrine in conflict of laws, which is also discussed in persons, which is the doctrine of processual presumption. So, what is this doctrine of processual presumption? The party who wants to have a foreign law applied to a dispute or case, he has the burden of proving the foreign law. You know, this doctrine is very, very popular when it comes to filing a petition for recognition of foreign judgment. One good example is a decree of divorce. Because if a divorce was obtained by reason of a foreign decree, a foreign judgment, and based on foreign laws, then that party who files the petition for its recognition and wants to have this foreign law applied to that particular petition has the burden of proving that foreign law. That foreign law is treated as a question of fact. That must be properly pleaded. So it must be alleged in the petition and it must be proved because the judge or labor arbiter, they cannot take judicial notice of a foreign law. He is presumed to know only domestic or foreign law. So what's the effect? In case there is failure to plead and proved that foreign law, the effect is that it will be treated as if that is covered by our municipal or domestic law. So what will be applied is our own laws. The foreign law being uh, or wants to be applied will not be applied in the instant petition. Let's proceed now to retroactivity of laws. As a general, laws shall have no retroactive effect. Lex prospicit non respisit unless the contrary is provided under Article 4 of the Civil Code. And by way of exceptions, these tax laws, interpretative statutes, laws creating new substantive rights, curative statutes, remedial or procedural, emergency laws, or when expressly provided by laws, penal laws favorable to the accused, provided the accused is not a habitual delinquent, laws will have retroactive effect. And by way of exceptions to these exceptions that we mentioned, there will be no retroactive of laws if the application of the retroactive law will impair obligation of contracts or is in the nature of ex post facto law or a bill of attainder, or if it divests vested rights or is constitutionally forbidden. Take note that in case of doubt, laws apply prospectively. All right. When it comes to judicial decisions, do they have retroactive effect? They do not have. So when a doctrine of the Supreme Court is overruled by a landmark decision or a new decision and a different view now is adopted, then the new doctrine should be applied prospectively. So it should not apply to the parties who had relied on the old doctrine and acted on the faith thereon. So clearly, there is no retroactive effect of judicial decisions. All right. There was already questions on the retroactive clause of the family code because as we said earlier, there is no retroactive effect. But the family code expressly provides that it will have retroactive effect insofar as it does not prejudice or impair vested or acquired rights in accordance with the civil code or other laws. One good example is in this case of inmates of the New Bilibid prison versus the Lima, now which is also an en banc decision. Because in this case, there was this Republic Act, Republic Act number 10592, which was signed into law during the time of then President Ninoy Aquino, which amended Articles 29, 94, 97, 98, and 99 of the revised penal code. So pursuant to the amendatory law, it is required that there should be an implementing rules and regulations, right? So there was this implementing rules and regulations jointly issued by Respondents Department of Justice, headed at the time by its former secretary, De Lima, and Department of the ILG, or Department of Interior and Local Government at the time, no, through Secretary Manuel Rojas. So clearly there, the grant of good conduct on time allowance accordingly should be applied prospectively. So that was precisely the contention of the petitioners. Sabi nila, that would be unfair, that would be unjust. So that should be applied it should have a retroactive effect. So the sole issue for resolution in these consolidated cases is the legality of these implementing rules and regulations of Republic Act 10592, which is the granting of good conduct time allowance, wherein it was stated earlier, I mentioned that it shall be prospective in application. So, what was the ruling of the Supreme Court? According to the Supreme Court, indeed, the administrative IRRs, the internal rules and regulations adopted by a particular department of the government under legislative authority, must be in harmony with the provisions of the law. So sabi ng Supreme Court, hindi pwede yun. It should harmonize. This IRR, which was enacted by reason of this law, should be in harmony with each other. So it should be the sole purpose of carrying the law's general provisions into effect. And the law itself cannot be expanded by such IRRs because an administrative agency cannot amend an act of the Congress. So, accordingly, every new law has a prospective effect. Under Article 22 of the Revised Penal Code, however, a penal law that is favorable or advantageous to the accused shall be given retroactive effect if he is not an habitual criminal. Di ba? We mentioned it earlier as one of the exceptions. So these are the rules, the exception, and the exception to the exception on the effectivity of laws. So, the prospective application of the beneficial provisions of this law, Republic Act 10592, actually works to the disadvantage of petitioners and those who are similarly situated. It precludes the decrease in the penalty attached to their respective crimes and lengthens their prison stay. So it will deprive them, no, of time off to which they are justly entitled to a practical manner. Thus, ang sabi ng Supreme Court, that should be applied retroactively, not prospectively. Another case is a case of Pulido versus People, penned by Justice Hernando. In this case, in this case, the Supreme Court recognizes the retroactive application of Article 40 of the Family Code, but only insofar as it does not prejudice or impair vested or acquired rights, as we mentioned earlier. Remember, in this case, Pulido is required to obtain a judicial decree of absolute nullity of his prior ab initio marriage, but only for purposes of remarriage. So, as regards to, kasi pinailan siya ng bigamy case in this case, no? And according to him, there was already he should that should no longer be applied to him. And as regards to that bigamy case, according to the Supreme Court, Pulido may raise the defense of a void ab initio marriage even without obtaining a judicial declaration of absolute nullity. But again, for purposes of applying this Article 40 of the Family Code, which apply retroactively on marriages celebrated before the Family Code, insofar as it does not prejudice or impair vested or acquired rights, a judicial declaration of nullity is required for prior marriages contracted before the effectivity of the Family Code, but only for purposes of remarriage. So, with that, thus the subsequent declaration of nullity, anyway, yeah, this is more to be discussed, no, in the criminal law, so we'll not anymore discuss this matter. Let's proceed now to mandatory or prohibitory laws. What's the effect of violation of mandatory or prohibitory laws? As a general rule, acts executed against the provisions of mandatory or prohibitory laws shall be void. We mentioned it earlier, right? By way of exceptions, when the law itself authorizes its validity, then it's valid. Like as what you can see on the screen, lotto, sweepstakes, na? What else? When the law makes the act valid, but punishes the violator, such as a marriage solemnized by a person not authorized to do so. Na? It makes the act merely voidable and not void. What else? When the law declares the nullity of an act but recognizes its effect as legally existing, such as the child born after the annulment of marriage, no, is considered legitimate. Let's proceed now to the next topic, which is waiver of rights. As much as possible, I trying my best to cover, no, what could be, no, possible questions as provided in the syllabus in civil law. No? Okay. So when it comes to waiver of rights, ang general rule, rights can be waived. Yeah, right? It may be waived, except if the waiver, again, is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. And also, if the right is a natural right, such as the right to life, and then inchoate, such as future inheritance. Like for example, no, dito sa prejudicial to a third person with the right recognized by law. For instance, if A owes B 10 million, B cannot waive the loan if B owes C and B has no other assets. So what are the requisites of a valid waiver? One is waiving party must actually have the right that he is renouncing. He must have full capacity to make the waiver. The waiver must be clear and unequivocal. The waiver must not be contrary to law, public order, public morals, and when formalities are required, no, they must be complied with. In the case of Abrogar, no, versus Cosmos Battling Company and Intergames, in this case, the petitioner's minor son died after being bumped, no, recklessly by a passenger jeepney along the route of the marathon, no, sponsored by the respondent in this case. It was the contention of the respondent that petitioner's son was allowed to join the marathon upon his waiver of all the rights and causes of action arising from his participation in the marathon. And on appeal, no, when this decision was elevated to the Court of Appeals, the Court of Appeals found that under the doctrine of assumption of risk, accordingly, there was voluntary exposure to the risk involved in the marathon. But the Supreme Court reversed this ruling. It found out that the waiver signed by petitioner's son, then a minor, was not an effective form of express or implied consent in the context of the doctrine of assumption of risk. Because clearly a person does not comprehend the risk involved in a known situation because of his minority, no? Because of lack of experience, because of lack of information. So he would not be taken to consent to assume that risk. In fact, the waiver stated the risk involved, no? Risks such as stumbling, suffering heart stroke, heart attack, other similar risks, but it did not consider vehicular accident as one of the risks included in the said waiver. But again, no, although the decision of the Court of Appeals was reversed, the court found the marathon organizer in this case, no, not the respondent, because the respondent herein is a mere sponsor. So the marathon organizer was found to be the party liable. So in case of doubt, no, in case of doubt, in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. No? Lumabas ng misa niya sa bar exams. And in case of silence, obscurity, or insufficiency of the law with respect to a particular controversy, if the law is silent or is obscure or insufficient with respect to a particular controversy, no, the judge shall apply, no, the custom of the place, and in default thereof, the general principles of law and justice. So speaking of customs, what are the requisites? No? As a general, by the way, no? As a general, a custom must be proved as a fact. No? As a fact, according to the rules of evidence, pursuant to Article 12 of the Civil Code. By way of exceptions, courts may take judicial notice of a custom if there is already a decision rendered by the said court, no, and recognizing such as a custom. So, what about the requisites before such custom could be considered a source of right? Plurality of acts, uniformity of acts, general practice by the great mass of the people of the country or community, the continued practice for a long period of time, the general conviction that the practice is the proper rule of conduct, then the conformity with laws, no, morals, or public policy. All right. Yung application of customs in civil cases, customs may be applied by the courts in cases where the applicable law is silent or obscure or insufficient, provided that said customs again are not contrary to law, public morals, etc. No? So the non-applicability of customs in criminal cases, no, kasi ang customs, this may be applied in cases, in civil cases, but not in criminal cases. Customs cannot be applied thereat. Why? Because of the legal maxim, nullum crimen poena sine lege. In short, there is neither crime nor punishment without a law. Okay? Okay. We proceed now to territoriality principle. You can find its basis under Article 14, no, of the Civil Code. Penal laws and those of public security and safety shall be obligatory, no, upon those who live or sojourn in the Philippines, no, subject to the principles of international law and treaty stipulations. So, yun yung mga exceptions. And the Supreme Court, no, expounded this concept of extraterritorial application when it sought to answer this question. May Philippine courts exercise jurisdiction over an offense constituting psychological violence under Republic Act 9262, otherwise known as Anti-Violence Against Women and Children Act of 2004, committed through marital infidelity when the alleged illicit relationship occurred or it's occurring outside the country. No? Anong sabi ng Supreme Court? It was explained by the Supreme Court that what the law punishes, sabi kasi ng Supreme Court, pwede, yung psychological violence. Though concubinage cannot be legally filed, but when it comes to psychological violence pursuant to Republic Act 9262, pwede. Ano? So citing Dinamling versus People, the highest court reiterated that psychological violence is an element of violation of Section 5, sa paragraph I, just like the mental or emotional anguish caused on the victim. Kaya in-apply yung extraterritorial effect. Psychological violence is the means employed by the perpetrator, while mental or emotional anguish, that is the effect caused to or the damage sustained by the offended party. The Supreme Court thus ruled that even if the alleged extramarital affair causing the offended wife mental and emotional anguish is committed abroad, Philippine courts have jurisdiction over this psychological violence under Republic Act 9262. Again, it was explained by the Supreme Court that what the law punishes is the violence against women and their children, not the marital infidelity per se. The Supreme Court added that the acts of violence against women and their children may manifest transitory or continuing crimes. Hence, a person charged with a continuing or transitory crime may be validly tried in any municipality or territory where the offense was in part committed. Okay? Okay. So, we now proceed to conflict of laws. And proceed now to discuss, provide concepts of this conflict of laws principles or doctrines, starting with lex nationality or the nationality principle. These are laws relating to family rights and duties, to the status, as to the status, conditions, and legal capacity of persons, which are binding upon citizens of the Philippines even though living abroad, pursuant to Article 15 of the Civil Code. In short, our law will run after you. All right. So are all marriages solemnized outside the Philippines in accordance with the laws enforced in the country where they were solemnized and valid there as such pursuant to Article 26 of the Family Code? Are they also valid in the Philippines? Kasi you might think of running from our laws, the effect of our laws, and your marriage will be solemnized in another country where it is allowed. So ang tanong, are all marriages solemnized? Be considered valid in the Philippines? No. Following the nationality theory or the nationality, if the marriage is void under Philippine laws, then that marriage is void. We cannot extend or recognize validity on such, even if it is valid in the country where the marriage was solemnized. Such as, what are those instances? Those contracted by any party below 18 years of age, even with the consent of parents or guardians. So akala mo, just because you were below the age of majority, you can run from our laws and married somewhere else, no? No, our law will run after you. What else? Those bigamous or polygamous marriages not falling under Article 41 of the Family Code. What else? Those contracted through mistake. No? Mistake of one contracting party as to the identity of the other. And those subsequent marriages that are void under Article 53. What else? Marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage. What else? Another one is incestuous marriage. And seven, void ab initio marriages for reasons of public policy. What about the rule on mixed marriage? Mixed marriage meaning a marriage between a foreign national and Filipino. As a general rule, we follow na, the principle of lex loci celebrationis. So we uphold the marriage. Hence, it is valid under the if it is valid, or we consider the same to be valid if it is considered to be valid under the law of one of the spouses, no, the foreign national or alien, and void, no, as regards to us. For example, a when it comes to a marriage, a mixed marriage between first cousins, we do not allow that in the Philippines if it involves a marriage between Filipinos. All right? But what if the marriage between first cousins was celebrated, for example, in Hong Kong, where it was validly celebrated, and that is a law allowed that, no, and not prohibited. So as far as our law is concerned, that is void, right? As far as the other contracting party, for example, if that is valid according to his own national laws, that marriage is valid, right? So in that case, we will uphold marriage because it is a mixed one, in order to preserve the sanctity of marriage and also to protect the Filipino spouse as well as their children. What about the rule on marriage between aliens and foreigners? Same rule applies. We uphold the marriage, no? But before, no, going further, no, by the way, yung going back again with this marriage, before I forgot, between Filipino and alien, we said earlier that as a general rule, we follow the principle of lex loci celebrationis. We uphold the marriage, right? But there are exceptions. Exceptions would be if the marriage is highly immoral or universally incestuous. Okay. So, going back now to this marriage between aliens and or foreigners, the same rule applies. As we said earlier, we uphold the marriage. So it is valid if it is valid under the law of one of the spouses and void under the law of the other, except again if the marriage is highly immoral or universally incestuous. All right. So we discuss another conflict of laws doctrine or principle, which is lex recite. Sometimes it is termed as lex situs. No, you can find its basis under Article 16, no, of the Civil Code. Real property and personal, as well as personal property, is subject to the law of the country where it is situated. All right. How about Lex Loci Celebrationis? Yan, ang mas sikat yan, yung Lex Loci Celebrationis, no? You can find its basis under Article 17, no? That is the forms and solemnities of contracts, wills, and other public instruments. These shall be governed by the laws of the country in which they are executed. So what governs the contracts involving the real property in the Philippines? It is governed by the proper law of the contract. It is not based on law of the place where the property is situated. This does not deal with title or real rights and deals instead with the contractual rights and liabilities of the parties. No? But of course, it will be a different scenario or a different application if, no, again, if it involves a conveyance of property, na? A transfer of property, because in that case, then what governs is lex recite, wherein real property as well as personal property is governed by the law where the property is situated. Okay, what governs the extrinsic or formal validity of contracts? This is governed by, as we said, lex loci celebrationis or lex loci contractus under Article 17. We said lex loci contractus. What is this? Or what is this principle? It means the law of the contract. Na? The law that governs the intrinsic validity of a contract. So how lex loci contractus is determined? It may be determined either through lex voluntatis or based on the or the law is specifically stipulated by the parties in their contract, or lex intentionis or the law intended, no, by the parties in the absence of an express stipulation. What governs the extrinsic or formal validity of will? Will, now we speak of will. It is governed by the law of the place where they are executed, pursuant to Article 17. Na? So, for example, no, while you were having a pleasure trip in Singapore, you notice, no, that there are notary publics there wherein you were, no, persuaded to execute a last will and testament, and it is not required, contrary to what is required in our laws, that there must be at least three witnesses. In Singapore, that was not required. So ang tanong ngayon, what governs the extrinsic or formal requisites, formal validity of will? As we said earlier, it is governed by the law of the place where they are executed. So if it is validly celebrated there and it does not require the requirement as we have in our country, then that's all right. Do we extend the validity? Yes. We recognize the same as valid because that is valid in accordance with the law of Singapore. But what if you executed this will instead before the Philippine embassy, before the Philippine consulate office in Singapore? Being an extended territory of our country, we should comply with what is required by our own law. That is, there should be at least three witnesses. And short of the requirement, we cannot extend validity of the will. Right? What about the intrinsic validity of will? What governs the intrinsic validity of will? This time, it is governed by the nationality rule of the decedent. And that applies whether Filipino or foreign national ang nag-execute ng will. Except if the decedent's national law follows the domiciliary theory. Na? So it is very clear that the national law follows the decedent or the executor, no, in his travels in accordance with Article 16, Paragraph 2 of the Civil Code. All right. What is this doctrine of renvoi or referring back? No? Referring back. This is a procedure whereby a jural matter presented is referred by the conflict of laws of the forum to a foreign state. Kaya nga referring back eh. So the conflict of laws or rules of which in turn refers the matter back to the law of the forum. Bumabalik uli Ano? Or even to a third state. So it is clear that renvoi can arise only from conflict rules, not from internal rules. So the second paragraph of Article 16, it provides that uh, in testamentary and testamentary succession, the national law of the person whose succession is in consideration, they shall govern. However, it may happen that the national law of a foreigner may refer back through this doctrine of renvoi, not the issue by providing that the law of the domicile of the decedent shall govern. All right. We leave now no conflict of laws and discuss now human relations no, in relation to person. What is this abuse of right? No? This is a right, no? Abuse of right. A right through by itself legal, no? Because it is recognized or granted by law. So why? Because it became the source of some illegality. So when a right is exercised in a manner which does not conform to the norms enshrined in Article 19 of the Civil Code and results in damage to another, then a legal wrong is thereby committed. No? So that wrongdoer must be held responsible or accountable for that. So this principle is based upon the famous maxim jus summa injuria, or the abuse of a right is the greatest possible wrong. So, what are the elements of this abuse of rights? There is a legal right or duty. Such duty is exercised in bad faith. It is for the sole intent of prejudicing or injuring another, and in the absence of good faith, no, which is essential to abuse of right. All right. What about contra bonus mores? Dalas lumabas sa bar exams niyan, no? Any person who willfully causes loss or injury to another in a manner that is contrary to law, morals, good customs, public policy shall compensate the latter to the damage, no? Pursuant to Article 21 of the Civil Code. So it fills countless gaps in the statutes, which leaves so many victims of moral wrong helpless, no? Even though they suffered material and moral damages. Okay. We proceed now to capacity to act. Ano ba yung mga restrictions sa capacity to act? Because remember, a person is presumed to have capacity to act. Na? So ano yung mga restrictions dito sa inborn mo na yan? Na? Yung this capacity to act. Minority. Na? Minority. The state of a person underage. No? And then insanity. Deaf mute. When it comes to deaf mute, only deaf mutes who do not know how to write. These are declared by law incapable of giving consent. What else? Imbecility and prodigality. When it comes to prodigality, prodigality per se, it doesn't automatically modify or restrict a person's capacity to act because there must be a declaration thereof by the court and be placed under guardianship under the rules on special proceedings. What else? Civil interdiction. That's another one. No? Civil interdiction, which is an accessory penalty imposed upon an accused who is sentenced to a principal penalty, no? Not lower than reclusion na temporal. And these are the effects of civil interdiction. No? Deprivation ng parental, marital authority, deprivation ng right to be a guardian, deprivation sa property by ac inter vivos, and deprivation of right to manage the owned property. By the way, the enumeration that we have cited, this is not exclusive. Let's proceed now to the rights of the conceived child. Since a conceived child has a provisional personality, even while inside the mother's womb, kaya may right na siya even inside the mother's womb, it is entitled to the right to support, the right to be acknowledged, and the right to receive donations. So what are the rules to apply in case there is doubt naman as to who died first? Depende po. It depends on whether the parties are called to succeed each other. If the successional rights are involved, kaya dapat titingnan mo ha? If successional rights are involved or if no successional rights are involved, tingnan mong mabuti. Because both, remember these two both are to be applied only in the absence of facts. Pero kung malinaw ang facts, I no need to apply. Oh, let us assume that there is an absence of facts. If successional rights are involved, then it is governed by Article 43, survivorship rule, and Rule 131. The presumption of simultaneous deaths between persons called to succeed each other apply. But if no successional rights are involved, you apply Rule 131, Section 3, double J, yung kanina double K, of the rules of court under this presumption of survivorship. Speaking of the presumption of survivorship, so let's discuss now the survivorship rule under Article 43. If there is doubt, again, as to who died first between two or more persons who are called to succeed each other as to which of them died first, then the burden of proof is whoever alleged the death of one prior to the other. He has the burden of proving such claim. Absent such proof, the presumption is that they died at the same time. There shall be no transmission, by the way, of successional rights. How about the conditions in the application of the survivorship rule? It applies when these conditions are present. The parties, number one, are heirs to one another. Second, there is no proof as to who died first. And third, there is doubt as to who died first. So what about the requisites in the presumption of survivorship and the Rule 131 of the Rules of Court? One is that there are, by the way, itong presumption under the survivorship, under the Rules of Court, is that the survivorship shall be determined from the probabilities resulting from the strength and the age of the sexes, according to these rules. Take note that these statutory rules in the determination of the sequence of death, they do not absolutely apply in a case where, again, liliwanagin natin, there is an indirect or inferential evidence surrounding the circumstances of the death. So if there exists that evidence, there is clearly facts, malinaw na may facts. So again, there are two or more persons, they perish in the same calamity, it is not shown who died first, and there are no particular circumstances from which it can be inferred that one died ahead of the other. All right. We now proceed to surnames. Surnames. What's the rule with regard to the use of surname of a married woman? What if I do not want to use the surname of my husband kasi mabaho, pangit, hindi magandang pakinggan? Let us discuss first, yung valid marriage before the husband dies, first name and maiden name, pwedeng gamitin mo yan. First name plus husband's name, pwedeng gamitin mo yan. Or husband's full name. Mrs. Tuazon, for example, Mrs. Ferdinand Tuazon. Or you may retain the use of your maiden name. Bakit ang dami mong choices? Kasi nga, the use of husband's surname, that is not a duty. It is merely an option for the wife. Alright? So if the marriage is annulled, pwede mo bang gamitin? Teka muna. tingnan mo muna, ikaw ba ang guilty party? No? Because if you are the guilty party, you should resume using your maiden name. But what if you are the innocent party? Then you have your choices. You resume using your maiden name or continue using your husband's name. Unless, of course, the court decrees otherwise, then she or the former husband is married again to another person. What about if you're legally separated? Kasal pa naman kayo. So the wife shall continue using the name and surname employed by her prior to the legal separation. Then, as regards to the widowed spouse, she may use the deceased husband's surname as though he is still living. No? All right. Uh, just take note of the case of this Remo, no, versus Secretary of Foreign Affairs, because in this case, Virginia Remo, a Filipino citizen, is married to Ralyonsa. In her passport, it appears that Ralyonsa is her surname, na? And Remo as her middle name. But prior to the expiration of her passport, she applied for the renewal, no, with the DFA, and she requests to revert her maiden name and surname in the replacement passport. She relied, no, on Article 370 of the Civil Code, wherein it is not a duty, di ba, for the wife to use the surname of the husband. It is merely permissive. It is not obligatory. It is not a duty. Tama ba si Virginia Remo? Sabi ng Supreme Court, mali. Why? Because tama yon. A married woman has an option, but not a duty, to use the surname of the husband in any of the ways provided under Articles 370 of the Civil Code. However, we have Republic Act 8239, ano? Or the Philippine Passport Act of 1996, which limits the instances when a married woman applicant may exercise the option to revert to the use of her maiden name. So these are the death of the husband, divorce, annulment, and declaration of nullity of marriage. So since wala ni isa that would be used, no, or utilized by Virginia Remo, then in the renewal of her passport, she had no choice, no, but to again use her husband's surname, which she already used, no, prior to the expiration or renewal of her passport. All right. Yan, Remo, no? So in case of renewal of passport, the Supreme Court in that case held that a married woman may either adopt her husband's surname or continuously use her maiden name. Tama yon. But however, once she opted to use her husband's surname in her original passport, she may not revert to the use of her maiden name except if any of the foregrounds that we have mentioned is present. All right? Etong case na ito, na? This case, no, may legitimate children have the right to use their mother's surnames as their surnames. This is a recently issued decision, no? Because the intention, no, of this petitioner is to use his mother's surname as his surname. Ang sabi ng Supreme Court, yes, no? Article 364 of the Civil Code, together with the state's declared policy to ensure the fundamental equality of women and men before the law, a legitimate child is entitled to use the surname of either parent as a last name. So this gives ample room to incorporate under Article 364 the state policy of ensuring this fundamental equality of women and men before the law, and no reason to ignore it. Thus, in this case, when this petition was dismissed, no, by the RTC, sabi ng Supreme Court, the RTC gravely erred, no, when it held that legitimate children cannot use their mother's surname, no? At walang naka-indicate that it should only be used, not that the legitimate children could only be used the surname of their father. Right? So let's proceed now to discuss the rules governing persons who are absent. Who are the person who may ask for the declaration of absence? By the way, pag sinabi mong absence, this is a special status of a person who has left his domicile and then thereafter his whereabouts could not be located, no, or is unknown, no, his fate is also unknown, it being uncertain whether he is already dead or still alive. So who are the person who may ask, no? The spouse present, the heirs, no, who instituted heirs instituted in a will, the relatives who may succeed by intestacy, and then persons who may have over the property of the absentee some right subordinated to the condition of his death. All right. So we proceed now to marriage. Dapat po ba i-memorize yung definition of marriage? Yes. Na? If you can, then you can memorize it. No, this is a special contract because you may cite it. No, once you will be asked, no, whether why is it that a same-sex marriage cannot or is not allowed, because the definition itself provides that it's a special contract or permanent union between a man and a woman. No? So marriage is not only for the purpose also of procreation, no, as you can see in the definition, or to have a family. Marriage is entered also for companionship purposes. And as again, clearly, marriage between same sex is void. But what if there is a change in sex? Can the person who has undergone said change be allowed to remarry? No. Another of the same sex as he or she originally had? It depends. It depends upon the case for the change in sex. If the change is artificial, he or she cannot, of course, no, because the sex or gender at the time of birth shall be taken into account. But if the taking into no the jurisprudence in the case of Silverio versus Republic, but if the change is natural, no, because he has this congenital disease, for example, then that can be allowed, no. All right. What are the requisites for a valid marriage? We have these essential requisites: legal capacity and then consent. Legal capacity, the age, the sex, no? The lack of legal impediment. No? Maliwanag na lack of legal impediment to marry, pursuant to Articles 37 and 38. And then consent, um, attainment of legal age pala, no, maliwanag, na not on the date of the filing of the application for issuance of marriage, but on the date of marriage. All right? And then consent. And then there are other requirements needed for the validity of marriage, which depend upon the age of the contracting party. 18 to 21 years of age, there is an additional requirement of parental consent and marriage counseling. And that between the ages 22 and 25, parental advice and marriage counseling is also required. As regards to formal requisites, the formal requisites are the authority of the solemnizing officer, a valid marriage license, and then a marriage ceremony. So let's see, no, the effect in the status of marriage in case of absence of any of the essential requisites. Wala, edi void ab initio. How about absence in any of the formal requisites? Void also. Kulang eh. That is required. By way of exceptions nga lang, it is valid even in the absence of formal requisite if it falls as marriages exempt from license requirement, no? Such as Articulo Mortis, etc., no? Or marriage by cohabitation, no? Under Article 35, etc., no? And either or both parties believe in good faith that the solemnizing officer had the proper authority to do so. Article 35, paragraph 2. What else? If there is a defect in essential requisites, defect lang ha, defect. Ibig sabihin, nandun may defect lang, voidable. Hindi void, voidable. How about the irregularity? Irregularity in formal requisites, again, nandoon naman, pero may irregularity lang. Valid. But the party responsible for such irregularity shall be civilly, criminally, or administratively liable. Yung marriage by proxy, by the way, no, depende, no, if it is performed in the Philippines, kaya it depends upon the place of celebration of marriage pursuant to Lex Loci Celebrationis. If it is performed in the Philippines, that is void because nationality rule applies since marriage is performed in the Philippines. But if it is performed abroad, whether it is allowed or not, it depends upon the law of the place where the marriage was celebrated. Okay. Then also there are other requirements, no, which will not render the marriage void, such as there were no witnesses, no, valid pa rin yan. The parties did not orally declare before the solemnizing officer that they take each other as husband and wife, valid pa rin yan. There was no marriage certificate or contract, valid pa rin yan, no? And then the effect of lack of parental advice, then the issuance of the marriage license, isususpend lang yan for 3 months from the completion of the 10-day publication of the application for marriage license. But what is the status of marriages celebrated during the suspension? Then, if the parties did not obtain a marriage license, it is void for lack of marriage license kasi absent ang marriage license. If the parties were able to obtain, no, it is valid, but without prejudice to the actions that may be taken again against the guilty party. All right. What about the effect of marriage if the certificate of legal capacity to marry was not secured by a foreign national? Because, again, kailangan niya yan, hindi ba? If he's going to marry here in the Philippines, that is valid. No? Valid because this is merely an irregularity. No? Irregularity in the compliance with the formal requirement in procuring a marriage license. It does not affect the validity of the marriage. And then we have this 5-year cohabitation, na yung cohabitation under article, I'm sorry, not article 35, I mentioned it earlier, article 34. No? Here, there is no required marriage license. The parties must just have to execute an affidavit stating that they are living together as husband and wife for at least 5 years, no? And that they do not have any legal impediment to marry. Maliwanag na iyang 5-year period na yan is characterized by exclusivity, wala silang ibang partner, no? And continuity for this whole 5-year period. All right. What about these rules governing the validity of marriage? As to extrinsic validity, nabanggit natin kanina, Lex Loci Celebrationis. As to intrinsic, personal law. No? Personal law may either be the national law or the law of the place where the person is domiciled. If the person involved naman is a stateless person, domiciliary rule applies. No? Otherwise, Lex Nationali applies. All right. We proceed now to Article 26, Foreign Marriages of Filipinos. As a general, marriage solemnized abroad, if valid in the country where celebrated, it shall also be valid in the Philippines under the Lex Loci Celebrationis principle. But there are exceptions, di ba? Yung binanggit na natin kanina yan earlier. And let's proceed now, no? To void and voidable marriages, no? Marriages. Status of marriage as to the nature, if it is a void marriage, it is inexistent. Inexistent from the time of its performance. Whereas if it is a voidable one, it's valid until annulled. So since it is a void marriage, it cannot be convalidated. That is in contrast with voidable marriage because it can be convalidated either by free cohabitation or prescription. And as regards to the effectivity on property, a void marriage, no, there is no community property, only co-ownership, to which we will discuss, no, later. And then voidable marriage, absolute community exists unless another system is agreed upon in marriage settlement. All right. As to effect, when it comes to their children, if it is a void marriage, children are considered to be illegitimate. No? By way of exceptions, if it is declared void by reason of non-compliance with Article 40, then the absolute community or conjugal partnership shall be dissolved, no, and liquidated. And in relation also to Article 50. And then when it comes to voidable marriage, children are considered to be legitimate, no, if conceived before the decree of annulment. At ang isa pang exceptions diyan sa void marriage is by reason of on ground of psychological incapacity, no? And then who may file? If it is a petition for declaration of nullity of marriage, then by the husband or wife. Tinitingnan ba kung sino ang, if for example, ang ground mo psychological incapacity, titingnan ba kung sino ang may psychological incapacitated, no need, no? Regardless of who, or even both of them, no problem. But in contrast with that, if it is a voidable marriage, it can only be filed by an offended spouse, no? Katulad ng legal separation. But by way of exceptions, Irene, this petition for annulment of marriage can be filed by the parents or guardians in case of insanity. No, these parents or guardian before the party reaches 21 years old on the ground of lack of parental uh, authority. No? And then, okay, and then the case of Tanandal, no, Rosana Tanandal, as we all know, and this is an en banc again, no, decision penned by Justice Leonen, wherein uh, the Supreme Court unanimously modified the guidelines on how to prove psychological incapacity as a ground for nullity of marriage under Article 36 of the Family Code. That psychological incapacity should mean no less than a mental, not physical, no, incapacity that causes a party to be truly incognitive of the basic marital covenants that concomitantly must be assumed and discharged by the parties to the marriage. So it must contain the same requisites of psychological incapacity. Hindi ito nabago sa guidelines, hindi nabago ng desisyon ng Tanandal. Juridical antecedents, gravity, permanence, or incurability. So it must be rooted in the history of the party antedating the marriage. Although there was this overt manifestations that arise after marriage. And it is grave enough to bring into the disability of the party to assume the essential marital obligations. Because again, that psychological incapacity is incurable, or if curable, that cure should be beyond the means of the parties involved. Okay? So, importante na yung binanggit dyan sa desisyon ni Tan Andal na there must be proof. In fact, ang tinitingnan is total evidence. Na? Total evidence. There must be proof that of the durable or enduring aspects of a person's personality called personality structure, no, which manifests itself through clear acts of dysfunctionality that undermines the family. So kailangan pa ba yung expert opinion? Hindi na, ano? No need anymore because it is not required anymore because what needs to be proven again, no, to prove the antecedent facts is to again proved that indeed this was already, no, in the person's personality structure even before, no? So hindi na mandatory required that there must be an expert opinion, no, on the party's psychological incapacity. How about if there are existence of grounds for legal separation? Does it preclude a finding of psychological incapacity on the part of one or both of the spouses? Because in this case, ang isang kiniklaim drug addiction, no? Ni Tanandal, no? Ang sabi ng Supreme Court ay yung drug addiction, tama, no? O similar or in any case other no grounds for legal separation, but in this case kasi drug addiction, no? That is a ground for legal separation, that's correct, but this will not prevent the court from voiding no the marriage. A degree of legal separation entitles spouses to live separately, diba, from each other without severing their marriage bond. But it is also possible that the marriage, no, though there was drug addiction, but it is attended by psychological incapacity of one or both spouses, no, with the incapacity manifested in ways that can be considered as grounds for legal separation. No? So long as a party can demonstrate that the drug abuse, for instance, is a manifestation of psychological incapacity existing at the time of marriage, this should be enough to render the marriage void under Article 36. Okay. So it is not a medical illness that has to be medically or clinically identified. Kaya nga hindi na required si expert witness, no? Okay. So the effects of judicial declaration of nullity of marriage, binanggit na natin kanina yan, no? Illegitimate yan, but legitimate if marriage is void on ground of psychological incapacity or due to non-compliance with the requirements set forth under Article 52. When it comes to property relations, either Article 147 or 148 applies to them. Yung co-ownership, no? Except if the subsequent marriage is void due to non-compliance with Article 40, the property relations of the void subsequent marriage will either be absolute, no, or conjugal partnership of gains. And then when it comes to donation propter nuptias, as a general revocable yan at the instance of the donor. By way of exception, if the donation propter nuptias is embodied in a marriage settlement, then the donation is void. If the subsequent marriage is judicially declared void by reason of Article 40, then the donation remains valid. No? But by way of exception to this exception, if the donee spouse contracted the marriage in bad faith, now all donations are revoked by operation of law. Na? And then, yung designation naman as beneficiary insurance policy may affect din. If the subsequent marriage is judicially declared void, then the innocent spouse, no, by reason of Article 40, the innocent spouse may revoke such designation if the beneficiary spouse acted in bad faith, even if the designation was stipulated to be irrevocable. What about the right to inherit? Pag intestate succession, the parties cannot inherit from each other by way of intestate succession. But when it comes to testate succession, any testamentary provision by one in favor of the other, valid yan. Except if the subsequent marriage is rendered void, again, by non-compliance with Article 40, in bad faith, disqualified to inherit from the innocent spouse. Take note that the parties are not disqualified to institute each other as voluntary heir in their respective wills to be executed after the judicial declaration of nullity. All right. When it comes to parental authority, custody of children, ang general rule, since the children are considered as illegitimate, the parental authority in the custody of children will be exercised by their mother. The illegitimate father, even if he admits paternity, will only have visitation rights. But by way of exception, if the marriage is declared void by reason of psychological capacity of either or both of the parties, yung parental authority and the custody will be exercised by the parent designated by the court. Okay. How about the requisites for validity of subsequent marriage under Article 41? The absent spouse had been absent for 4 consecutive years that is referring to ordinary absence, or 2 consecutive years, o yun yung extraordinary absence. And then the present spouse has a well-founded belief that the absent spouse is already dead. No? Pag sinabi mong well-founded belief, it requires the present spouse to prove that his or her belief was the result of a diligent and reasonable efforts to locate the absent spouse. And based on these efforts or her efforts and inquiries, he or she believes that under the circumstances, the absent spouse is already dead. Na? So kinakailangan may active effort, hindi passive. What else? There is a judicial declaration of presumptive death in a summary proceeding. Kasi bakit? Your intention is to remarry. All right. Let's proceed to the circumstances constituting fraud, no, in order to annul the marriage under Article 45, Paragraph 3. We have the non-disclosure of conviction by final judgment of crime involving moral turpitude, concealment by the wife of the fact that at the time of marriage she was pregnant by man other than her husband, the concealment of sexually transmitted disease, regardless of nature existing at the time of marriage, and then concealment of drug addiction, habitual alcoholism, homosexuality, and lesbianism. Kaya may panluloko, may deceit may concealment. But when there has been no misrepresentation or fraud, such as, for example, the husband at the time of the marriage knew that the wife was pregnant, ang laki-laki na ng tiyan, nahalata naman, the marriage cannot be annulled because there could be no concealment to that. No? Okay, and then take note no, of the grounds no, in voidable marriage. We'll no longer discuss one by one. And then, anong effects ng decree of annulment? Yung absolute community property regime or conjugal partnership regime terminated na yan, dissolved, no? And that must be liquidated. The innocent spouse may revoke the designation of the other spouse who acted in bad faith as beneficiary in the insurance policy, whether or not yung designation is irrevocable, no? And then the spouse who contracted the marriage in bad faith shall be disqualified to inherit, as we said earlier, from the innocent spouse by testate and intestate succession. Di katulad dun sa effect ng void marriage. And when it comes to donation propter nuptias, ang general, it shall remain to be valid, except if the donee spouse acted in bad faith, the donor may revoke the donation. All right. And then, pag lumabas ang desisyon ng final ng annulment or nullity no ng marriage, kasama na rin diyan yung it covers the liquidation, the partition, distribution ng properties ng spouses, custody and support no of their children, etc. no. So in which case hindi na dapat just in case merong nauna ng custody for example na case, then the final judgment or the final judgment on nullity or annulment did not provide it anymore kasi meron no, it has been adjudicated already. Kung wala, kasama pa rin yon sa desisyon na. Okay, we proceed now to legal separation. Can the guilty spouse file and claim legal separation? Hindi nga pwede. That is not allowed to him no or to her because only the innocent spouse is allowed to file the same. So anong mga grounds for legal separation? You need to memorize it. No? Repeated physical violence, repeated, no? Grossly abusive conduct, attempt to corrupt, sino-sino, attempt by respondent against the life of petitioner. So dito sa tatlo na ito, no criminal conviction is necessary now to issue a decree of legal separation. Sa legal separation, by the way, preponderance of evidence is enough. And then we have final judgment, sentencing respondent to imprisonment more than 6 years, even if pardoned. and then drug addiction or habitual alcoholism or respondent that must exist after celebration of marriage, and then physical violence or moral pressure, no, to change religion or political affiliation, then bigamous marriage subsequently contracted, no, whether in the Philippines or abroad, sexual infidelity or perversion, lesbianism, homosexuality, no, of respondent. Ano naman ang reason why the petition for legal separation is denied? May condonation, consent, connivance, collusion, mutual guilt, or prescription. Kasi ang prescriptive period, 5 years from the occurrence or cost. Then, death of either party during the pendency of the case, or nakabate, reconciliation of the spouses during the pendency of the case. Okay, so yung cooling off period sa legal separation, mandatory yan, di ba? But kaya hindi agad uh, tinatry, no, or hinihir before 6 months has elapsed, no, since the filing of the petition. Why? To enable the parties to settle their differences for possible reconciliation. But that period is not followed if the grounds alleged are those under Republic Act 9262, because in that case, the court can immediately hear the case. Anong effects ng legal separation? The spouses are entitled to live separately, no? Separately from, but the marriage bond is not severed. Yung kanilang property relations, no? Absolute community of property or conjugal partnership of gains shall be dissolved and liquidated. The share of the offending spouse in the net profits, this shall be forfeited in favor of the common children, and in default of common children, no, children of the guilty spouse by previous marriage, and then in default of common children and the children of the guilty spouse, the innocent spouse. Then yung custody awarded to the innocent spouse, subject to Article 213, yung tender age principle, no? And then the offending spouse is qualified to inherit by intestate succession from the innocent spouse. Yung provisions in the will of innocent spouse, which favors offending spouse, it shall be revoked by operation of law. Yung prescriptive, ayan, period, no, dito sa revocation ng donation, 5 years yan from finality of the decree of legal separation. And then the innocent spouse may also revoke the designation in the insurance policy even if the stipulation is irrevocable. Okay? Let's proceed now to donation propter nuptias. When it comes to, pag sinabi mong donation of propter nuptias, these are donations which are made before, no, the celebration of the marriage, in consideration of the marriage, and in favor of one or both of the future spouses. So yung formalities ng donation propter nuptias follows the same formalities as set forth in the law on donation. Pareho lang. No? So yung donations of future property, these are governed by provisions on testamentary succession and formalities of wills. So take note na sa donation of propter nuptias, yung present property may be donated up to 1/5 of the donor's present property if the future spouses have chosen a regime other than the absolute community of property. Katulad ba yan ng ordinary donation? Hindi. Kasi sa ordinary donation, walang limit, no? So long as merong reservation at hindi ka naka-impair, no, ng legitime. What about yung future property? Ano? Future property may be included. Sa ordinary donation, hindi pwede. Ano? So sa donation propter nuptias, pwede ang future property provided na ang donation is mortis causa. And then the grounds for revocation are found in Article 86 of the Family Code. Okay? So ang requisites lang yan, it must be made before celebration of marriage, it must be made in consideration of marriage, and it must be made in favor of one or both of the future spouses. Ano naman ang requisites if the donation propter nuptias or donation by reason of marriage is made by one spouse in favor of the other? Dapat merong marriage settlement stipulating a property regime other than the absolute community. Yung donation in the marriage settlement should not be more than one-fifth, di ba? Yun ang limit of the present property. And there must be acceptance by the other spouse. If there is an excess, any excess is considered void. By way of exception, if they are governed by absolute community of property, then each spouse can donate to each other in their marriage settlements present property without limit, now provided that there is a sufficient property left for their support and the legitimes are not impaired. Paano kung ang dinonate sa'yo encumbered? No? Still valid. The donation is still valid. But in case of foreclosure of the encumbrance and the property is sold for less than the total amount of the obligation secured, then the donee shall not be liable for the deficiency. But if the property is sold for more than the total amount of the obligation, entitled si donee sa excess. So these are the instances where donations may be revoked by the donor, no? Ito yung donation propter nuptias pa rin tayo, no? A donation kasi by reason of marriage may be revoked by the donor in these cases, no? Pag ang marriage is not celebrated or is judicially declared void ab initio, as a general rule, pwede mong i-revoke yan. But by way of exception, yung mga donations made in the marriage settlement, such as marriage take place without the required consent of parents or guardians, yan, no? Pwede. Marriage is annulled and the donee acted in bad faith. Also, upon legal separation, the donee, no, may being the guilty spouse, pwede mo pa rin i-revoke yan. And if with a resolutory condition which was complied with. Also, when the donee has committed an act of ingratitude. Okay. So, pagdating naman sa absolute community of property, applicable ito when spouses adopt it in a marriage settlement, o they do not choose any economic system, automatic iyan na yan. Or adopted a different property regime and the same is void. So, ang i-apply ito. Ano ba yung mga dapat kasama dyan? All the property owned by the spouses at the time of the celebration of marriage or acquired thereafter, o yung mga property acquired during the marriage by gratuitous title, if expressly made to form part of the community property by the donor, testator, or grantor, and jewelry or properties with monetary value, and winnings in gambling. Ano naman yung hindi kasali? Ito yung mga properties excluded dyan sa absolute community. Ito yung mga property acquired during the marriage by gratuitous title, no? And its fruits, as well as income thereof, unless expressly provided yan ni grantor, no? That they shall form part of the community property. Whereas, the property for personal and exclusive use of either spouse, but jewelry shall form part of the absolute community property because of their monetary value. No? And then, property acquired before the marriage by one with legitimate descendants by former marriage and its fruits and income, if any, and those excluded by the marriage settlement. Ano naman yung sa conjugal partnership gains? Kailan mo naman i-apply yan? When the future spouses adopt it in a marriage settlement, or if the marriage is celebrated under the civil code, no? Mga parents natin, di ba, before the effectivity of the family code, and they have not adopt any economic system. Then, itong tinatawag na conjugal partnership of gains, it is the property relation formed by the husband and the wife by placing in a common fund yung proceeds, yung product, yung fruits and income of their separate properties, and also those acquired by them or both of them through their effort or chance. How about yung complete separation ng property? Kailan nag apply yan? Kung yan ang pinili uli, if the future spouses adapt in a marriage settlement or na-dissolve ang absolute community of property or conjugal partnership of gains. Or prior marriage is dissolved due to death of one spouse and the surviving spouse failed to comply now with the requirements under Article 103 or the judicial settlement proceedings of the estate of a deceased spouse. Also by judicial order, judicial separation of property, take note, may either be voluntary or for sufficient cost. Speaking of judicial separation of property, ano ba ang mga causes niyan? For judicial, filing a petition for judicial separation of property. One, pwedeng ang ground mo civil interdiction, no? Of the spouse, of the petitioner. Pwedeng judicial declaration of absence, loss of parental authority as decreed by the court, abandonment or failure to comply with family obligation, o administrator spouse naman has abused authority, no? O yung separation in fact for 1 year and reconciliation is highly improbable. So, yung in cases in numbers 1, 2, and 3, the presentation of the final judgment against the guilty or absent spouse shall be enough basis for the grant of the decree of judicial separation of property. So ano ang effect or effects of judicial separation of property between the spouses? Nadidissolve yung absolute community or yung conjugal partnership. Yung liability of the spouses to creditors, they shall be solidary, no, with their separate properties. And yung mutual obligation to support each other continues, except when there is a legal separation. And the rights previously acquired by creditors, these are not prejudice. In case of, sabi natin kanina, pwedeng with cause or voluntary, di ba? In case of voluntary agreement of the separation of property by the spouses, the law does not require specific reasons to justify na, in approving the same. Kasi bakit? Voluntarily agreed nila yan eh. No? So, no need. Okay? Let's proceed now to discuss another important topic in civil law, which is the property union without marriage. No? Kasi nakakalito yan kung hindi mo titingnan mabuti eh. Yung Article 147 vis-a-vis from Article 148. Madalas ba lumabas sa bar exams? Madalas. So, kailan nag-a-apply yan? Yung Article 147, nag-a-apply to if the parties have no legal impediment to marry. Tandaan mo ha, nag-live-in, pero dalagat binata naman sila. Ha? Walang wala silang kompromiso. No? No legal impediment to marry. Also, nag-a-apply rin yan sa void marriage on the ground of psychological incapacity. Katulad ng case ni Tan Andal. Yan ang in-apply, Article 147. How about yung Article 148? Ito yung nag-a-apply kung may legal impediment caused by adulterous relationship, bigamous or polygamous marriages, incestuous void marriages, no, under Article 37, and void marriages by reason of public policy. So ano mga requisites? Ang requisites dyan, the man and woman in Article 147 must be capacitated to marry. Ayun na nga yung binanggit natin kanina. No? So unlike in Article 148, may legal impediment. And yung salaries, when it comes to salaries and wages, sa Article 147, it is owned in equal shares. Sa Article 148, separately owned yan. No? If one is married, his or her salary pertains to the Ayun ang masakit. Conjugal partnership of gains of the legitimate marriage. How about the property exclusively acquired? Yung Article 147, it belongs to the party upon proof of acquisition through exclusive funds. Sa Article 148, it belongs to the party who acquired the same. And as regards to property acquired by both through their work or industry, under Article 147, it is governed by the rules on co-ownership. Article 148, it is owned in common in proportion to their respective contributions. At ang presumption sa Article 147, yung property acquired while living together is presumed to have obtained by their joint efforts, no? Work or industry and owned by them in equal shares. So kahit na ang kinontribute mo lang, minamasahe mo lang yung husband mo, okay lang yun. Moral support ang ginagawa mo, okay lang din yon. If one party did not participate in the acquisition, it is presumed that that party have contributed through care and maintenance of family and household. Pareho ba yan sa Article 148? Walang presumption of joint acquisition dito. Actual joint contribution of money, property, or industry, it shall be owned by them in common proportion. However, their contributions, these are presumed equal in the absence of proof to the contrary. Pagdating sa proof of actual contribution, kailangan ba sa Article 147? No need. Not necessary. Sa Article 148, necessary. Alright. When it comes to forfeiture, sa Article 147, when only one of the parties to a void marriage is in good faith, yung share ni party in bad faith, in the co-ownership, ipoporfeit yan. How about si Article 148? If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community of property or conjugal partnership of gains existing in the marriage. If the party who acted in bad faith is not validly married to another, or if both are in bad faith, such share shall be forfeited in a manner provided in the last paragraph of Article 147. Forfeited. Let's discuss now family relations. So family relations, it includes family relations between husband and wife, between parents and children, among other ascendants and descendants, among brothers and sisters, whether of full or half blood. So a suit between a brother-in-law and a sister-in-law is not within the coverage of the law. Kaya if there is failure on the part of the plaintiff to allege earnest effort to effect a compromise, that is not necessary. The relationship is based on consanguinity, except that of the husband and wife. So itong enumeration na ito, the enumeration of brothers and sisters as member of the same family does not comprehend brothers or sisters-in-law. So ang rules, family relations exist even if they are not living together. Illegitimate children, they are not included in the family relations under this article because they have their own families. Adopted children, they are included. Ano ang requisites before a suit between members of the same family may prosper at hindi ma-dismissed? There must be earnest effort toward compromise, and such effort failed. And that fact, that earnest efforts toward the compromise have been made but failed, it should appear in the verified complaint or petition. Meron bang mga hindi ka pwedeng i-compromise? Yes, the following cannot be compromised, like the civil status of persons, validity of a marriage or legal separation, any ground for legal separation, future support, jurisdiction of courts, and future legitime. Ano? What is a family home? Ang family home, it is constituted it is constituted jointly by the husband and the wife or by an unmarried head of the family, the dwelling house where they and their family reside, no? And the land on which it is situated. So kasama yung bahay at lupa. Ayan. So maliwanag that the family home must be family home is deemed constituted from the time of the actual occupation as a family residence, and only one family home may be constituted. It must be owned by the person constituting it, and it must be permanent. And also, it continues despite death of one, both spouses or an unmarried head of the family for 10 years, as long as there is a minor beneficiary. And it must be part of the properties of the absolute community or conjugal partnership or exclusive properties of either spouse, no? But with the latter's consent. And it may also be constituted by an unmarried head of the family on his or on her property. Okay. Pwede bang i-attach ang family home? No? May this be attached? No. From the time of the Constitution and so long as any of the beneficiaries actually reside therein, the family home, no, the family home, I mean, continues to be as such, no, and is exempt from attachment, execution, no, for sale, except as provided under this law and to the extent of the value allowed by law, no. Is this absolute? Sabi natin, hindi, because there are instances wherein it is exempt, no. It shall not be exempt from execution, attachment, for sale, no, such as for non-payment of taxes, for debts incurred prior to the constitution of family home, for debts due to laborers, mechanics, architects, builders, material men, and others who have rendered services or furnished material for the construction of the building. Bakit exempt? Bakit exempt? To place it beyond the reach of ordinary creditors, no? Anong limitations sa family home? Each family can only have one, no? Binanggit na natin kanina yan. And it can be constituted on the dwelling place and therefore in the locality where the family has its domicile, and it must not exceed the limit fixed by law. And the family home, no, is a real right which is gratuitous, inalienable, and free from attachment, as we've made mention, except, no, do sa mabinanggit nating instances. Okay? So, okay. When it comes to the requisites, no, for the by the way, we proceed now, no, with the fact, no, whether or not a family home be sold if there is an increase in its value. To warrant the execution sale of the family home, there should be the facts that need to be established is that there was an increase in actual value. The increase resulted from voluntary improvements on the property introduced, and that the increased actual value exceeded the maximum allowed, no, under Article 157. And who are, no, the beneficiaries of a family home? The husband, as we mentioned, the husband and wife, unmarried, no, person, nabanggit na pala natin kanina, no, so we'll not anymore discuss them. And okay, Okay, so to continue our discussion, we proceed now to discuss paternity and filiation. So, paternity and filiation, ang paternity, as we all know, is the civil status of the father with regard to the child, and then filiation is the civil status of a child with regard to the parents. So, what proof of evidence is required to establish paternity and filiation? The high standard, no, high standard of proof is required, no, through clear and convincing evidence. And what are the classifications of filiation? We have natural, no, we have by way of natural is legitimate and illegitimate, and then we have the judicial act, no, which is legitimated and then adopted. As regards to natural, legitimate children, as a general rule, is one who is conceived or born during the marriage of parents. And by way of exception, they are born outside of a valid marriage or void marriages, but considered a legitimate child. No? Because there are children of marriage which are declared void under Article 36, or children of marriages which are declared void under Article 53. Is a child born out of artificial insemination legitimate? Yes, provided that both parents authorized or ratified such insemination, no, in a written instrument executed and signed by them before the birth of the child. And then this instrument shall be recorded in the civil registry together with the birth certificate of the child. Article 164 on presumption of legitimacy provides that the children conceived or born during the marriage of parents, they are considered to be legitimate. And this presumption of legitimacy of children, it does not only flow out from a declaration, no, contained in the statute, but it is based on the board principles of justice, no, and the supposed virtue of the mother. Thus, this presumption is to protect the innocent offspring, no, from the odium of illegitimacy. So, what is the effect of the declaration of a wife against the legitimacy of the child, where the child is conclusively presumed to be the legitimate child of husband and wife? So this law likewise applies to such instances where the mother may have been sentenced as an adulteress. No, Article 167 applies only to a situation where the wife denies the paternity of the husband. It does not apply where a child is alleged not to be the child of nature or biological child of the couple. All right. What about the grounds for impugning the legitimacy of a child under Article 166? We have physical impossibility for the husband and not to have sexual intercourse with the wife because of the fact that he has serious illness at the time, no, which absolutely prevented him to have sexual intercourse, or his physical incapacity, and the fact that they were living separately from each other. And in case of children conceived through or proved, no, that for biological or other scientific reasons they could not have been that of the husband, except of course, no, if they have been conceived through artificial insemination. And for those children conceived through artificial insemination, there should be that written authorization or ratification without any vices of consent. Who are the persons who may attack the legitimacy of the child? As a general, only the husband, no, can contest the legitimacy of the child. By way of exceptions, the heirs of the husband within the period prescribed, no, only if in the following cases. If the husband should die before the expiration of the period fixed for bringing the action, if he should die after the filing of the complaint without having desisted therefrom, and if the child was born after the death of the husband. So let's proceed now to discuss the illegitimate child. The illegitimate child, madalas ba lumabas sa bar exams? Madalas yan, na? There are children conceived and born outside a valid marriage. They are the children born of couples who are not legally married or of common law marriages. There are also children born of incestuous marriage. There are also children born of bigamous marriage, born of adulterous relations between parents, and children both of born of marriages which are void by reason of public policy, or also children born of couple below 18 years of age, and also children born of void marriages. Let's proceed now to discuss Republic Act 9255. This is an act which provides the illegitimate child, no, to optionally use the father's surname, provided that the filiation has been recognized by the father through the record of birth appearing the civil register, and also with the admission in the public document or private handwritten is made by the father. Take note that the father has the right to institute an act before the registrar, no, or before the regular courts, I mean, to prove the non-filiation during his lifetime. So, what about legitimation? Legitimation is a remedy or process by means of which those who, in fact, are not born in wedlock and should therefore be ordinarily illegitimate are by fiction considered to be legitimate. As who are these children entitled to legitimation? Only children conceived and born outside of wedlock of parents who at the time of conception were not disqualified, no, by any impediment to marry each other, or were so disqualified only either because either or both of them were under 18, who may impugn legitimation only by those prejudiced in their rights, no, within 5 years from the time their cause of action accrues, no, that is from the death of the putative father or parent. When it comes to action to claim filiation, who are the persons who may file, no, this claim legitimate filiation or illegitimate filiation? It belongs to the child as a general rule. Na? That is questioning illegitimacy may not be collaterally attached. No? It can only be impugned by the way indirect action. By way of exception, the right is transferred to his heirs, no, when the child dies during his minority or in a state of insanity or after commencing the action for legitimacy. And what is the prescriptive period, no, to claim legitimacy or illegitimacy? By the child, it must be during his lifetime. By his heirs, within 5 years, no, should the child dies during minority or in a state of insanity or other commencing, no, action for legitimacy, provided that the action for illegitimacy is based on admission of paternity, no, or filiation in the birth certificate of a written instrument, if based in open and continuous processing of status or any other means, the action must be brought during the lifetime of the alleged parent. Okay, so what are the different kinds of filiation? We have primary and secondary. Primary, which is the record of birth, admission of legitimate filiation, no? Ang secondary, yung open and continuous possession ng legitimacy and other means, no, allowed by law. Yung mga pictures or baptismal, they do not constitute authentic documents to prove filiation. All right, let's proceed now to adopted children. Adopted children, the proceedings now is no longer judicial. It is now administrative by virtue of Domestic Administrative Adoption and Alternative Care Act, no, under Republic Act 42, no? Approved on took effect, no, on January 28, 2022. So as we said, the proceedings now are administrative. It is now rested under the original and exclusive jurisdiction uh, before the National Authority for Child Care, or NAC. So it will have the original and exclusive jurisdiction over all matters pertaining to alternative childcare, no, including declaring a child legally available for adoption, domestic administrative adoption, adult adoption, foster care adoptions under Republic Act 11222, otherwise known as the Simulated Birth Reclassification Act, and including the intercountry adoption. Okay? It is attached to the Department of Social Welfare and Development, who may adopt any Filipino citizen at least 25 years of age who is in possession of full capacity and legal rights, not convicted of any crime involving moral turpitude, of good moral character, at least 16 years of age, emotionally and psychologically able, no, of caring the child, provided na yung requirement of 16 years differences of the age between the adopter and adoptee may be waived when the adopter is the biological parent of the adoptee or is the spouse of the adoptee's parents. Who else? The legal guardian. Huh? The legal guardian with respect to the ward after the termination of the guardianship and clearance of financial accountabilities. And also, the legal guardians, no, with respect to the foster child. Philippine government, pwede rin, no? Philippine government officials and employees deployed for station abroad, provided that they are able to bring the child with them. And foreign nationals who are permanent or habitual residents of the Philippines for at least how many years? 5 years. 5 years of possessing the same qualification as that we have stated for Filipino nationals. No, that is prior to the filing of the petition for administrative adoption, provided that they come from the country with diplomatic relations, no, diplomatic relations with our country, and that of the adopter's country, no, under the laws, no, of the adopter's country, which will acknowledge the certificate of adoption as valid, because there are countries who do not issue the same. No, so we have to make sure that the child, no, would be allowed entry thereat, and provided further that by the way, itong requirements of residency, this may be waived if the adopter, no, the foreign national, is a former Filipino citizen habitually residing in the Philippines who seeks to adopt a relative within the fourth civil degree of consanguinity or affinity, or one who seeks to adopt the legitimate child of the Filipino spouse, or one who is married to a Filipino citizen and seeks to adopt jointly with the spouse a relative within the fourth degree of consanguinity or affinity of the Filipino spouse. Yung spouses, they should jointly adopt, except and if one spouse seeks to adopt the legitimate child of the other. So no need. If one spouse seeks to adopt its own illegitimate child, provided that the other spouse has signified consent thereto, or if the spouses are legally separated from each other. Who may be adopted naman? Any child, who has been already issued na ACDCLAA, yung kanilang magiging basis, of course, itong i-issue sa kanila na ng National Authority for Child Care. Okay? So, any child who has been issued with such, no, and then the legitimate spouse, the legitimate child, no, of one spouse by the other spouse, an illegitimate child by qualified adopter, a Filipino of legal age, no, if prior to the adoption the person has been consistently considered and treated as adopters of their own child for a period of at least 3 years. A foster child, a child whose adoption has been previously rescinded, a child whose biological or adoptive parents have died, provided na yung proceedings shall be initiated, no proceedings shall have been initiated within 6 months, no? From the time of death of said parents or a relative of the adopter. Ano ang effect ng decree of adoption? Etong importante dyan. As regards to legitimacy, iyan ang nabago sa law na yan. The adoptee shall be considered, di ba? Alam natin yan, the legitimate child of the adopter for all legal intents and purposes. Alright? So, ano pa ang pagkakaiba ngayon yan? This time, with this law, the legitimate filiation that is created between the adopter and adoptee is now extended to the adopter's parents, adopter's legitimate siblings, and legitimate descendants. Sa makatwid, yung kanilang relationship is not only between the adopter and the adoptee. It now extends with the family of the adopter. Kaya yung grandparents, meaning the parents of the adopter, will now be considered as his or as her grandparents. All right? Let's proceed now to discuss support. What is support? Support comprises everything, no? Indispensable for the sustenance, dwelling, clothing, medical attendance, transportation, no? Even beyond the age of majority. So what are the characteristics of support? Personal yan. Reciprocal on the part of those who are by law bound to support each other. It is intransmissible, it's mandatory, it has a provisional character of support judgment. It is exempt from attachment or execution, and it is not subject to waiver or compensation. So what comprise support? What comprise support? Support comprised everything indispensable for sustenance, dwelling, clothing, medical attendance, education, no? Including schooling or training for some profession, take note, trade or vocation, even beyond the age of majority. And it also includes transportation, no? Of going to and from the school or from place of work. What are the rules on support of illegitimate children of either spouse? It depends upon the property regime of the spouses. The absolute community of property or conjugal partnership for the support of the following: the spouses, the common children of the spouse, and the legitimate children of either spouse. So if the community property of the conjugal partnership is insufficient to cover them, then the spouses shall be solidarily liable for the unpaid balance with their separate properties. And then the separate property of person, no? For the support of the following: illegitimate children, legitimate ascendants, the descendants, whether legitimate or illegitimate, brothers and sisters, no? Whether legitimately or illegitimately related. What about the persons obliged to support? Sino-sino ba yan? Spouses. Yan. The spouse must be the legitimate spouse, ang pinag-usapan natin dito, in order to be entitled to support. Legitimate ascendants and descendants, the parents and their legitimate children, and the legitimate and illegitimate children of the latter. The parents and their illegitimate children, and legitimate and illegitimate children of the latter. And then the legitimate brothers and sisters, whether full or half-blood. Are brothers and sisters not legitimately related, likewise bound to support each other? Yes. But by way of exception, when the need for support of the brother or sister being of age, no, is due to a cause imputable to the claimant's fault or negligence. In that case, the illegitimate brother or sister has no right to be supported. So ano yung order on persons liable to support? Spouse, descendants in the nearest degree, and then ascendants in the nearest degree, then brothers and sisters. Okay? And then what is the rule on the amount of support? It shall be in proportion to the resources or means of the giver and the necessities of the recipient. So it depends upon the capability and needs. Can it can this support be decreased or increased? Yes. It must be in accordance with the necessities, di ba? And needs. Kaya adjustable yan. Demandable ba yan? The obligation to give support is demandable kailan? From the time the person who has a right to receive support needs it for maintenance. So the support shall be paid only from the date of the judicial or extrajudicial demand. The right to support does not arise from mere fact of relationship, by the way, but from imperative necessity without which it must or it cannot be demanded. Okay? So the law presumes that such necessity does not exist unless support is demanded. So what is the effect of reaching the age of majority of person na being supported? Dire-diretso pa ba? If a person is of age and no longer studies, he is still entitled to support unless there are just reasons for the extinguishment of the right. If on the other hand, he has not yet finished his studies, even if he's already of age, ang tagal kinuha ng law, for example, he's still entitled generally to be supported. No? Of course, if the person supporting dies, tapos na. No? The obligation ceases. So what is the manner of payment? First 5 days of each corresponding month. And in case of death of the person entitled to receive support, his heirs, by the way, shall not be obliged to return what has been received in advance, no, for such support. All right. So, pwede namang may option niya pagbibigay ng suporta, no? Pwedeng fixed monthly allowance or to receive and maintain the recipient in the giver's home or family dwelling. What if the support is given by a stranger without the knowledge of the person obliged to support? As a general rule, ang stranger shall have the right of reimbursement, except no, unless it appears that he gave it without any intention of being reimbursed. If the person obliged to give support unjustly refuses or fails to give it when urgently needed, then any third person no, may furnish support to the needy individual with a right of reimbursement. Okay. So let's proceed now to discuss parental authority. Parental authority, this is a mass of rights and obligations which parents have no, in relation to the person and property of their children under their emancipation and even after their after this, no, under certain circumstances. It includes caring for and rearing of their children, for the development of their moral, mental, no, and physical character and well-being. So ano yung mga characteristics of parental authority? Number one, kinakailangan jointly exercise yan by the parents. It's a natural right and duty of the parents. As a general, it cannot be renounced. It cannot be transferred. It cannot be waived, except in cases authorized by law, no? Such as in cases of adoption, guardianship, and surrender to a children's home, no? Or an orphan institution. It is purely personal and it is also temporary. Who exercise parental authority? The father, mother, no? They shall jointly exercise as we mentioned earlier. In case of disagreement, the father's decision shall prevail unless there is a judicial order to the contrary. If the child is illegitimate, then parental authority is with the mother. Ito bang parental authority and responsibility na to, alienable yan? They are inalienable. They may not be transferred or renounced, as we said earlier, in cases authorized except no, in cases authorized by law. It is purely personal, remember? Kaya hindi pwedeng i-transfer. The law allows a waiver of parental authority only in cases of adoption, guardianship, and surrender to children's home or orphans institution. How about the parental preference rule? The natural parents who are of good character, and who can reasonably provide, no, for the needs of their children, they're ordinarily entitled to the custody as against all persons. How about substitute parental authority? It is the parental authority which the persons designated now by law may exercise over the persons and property of unemancipated children in case of death, absence, or unsuitability of both parents, or in default of a judicially declared guardian or judicially appointed guardian. Ano yung order ng substitute parental authority? Number one, si surviving grandparents, si oldest brother or sister over 21 years unless unfit or disqualified, actual custodian over 21 years, no? Uh, unless unfit or disqualified, and in case of foundling, abandoned, neglected, or abused, parental authority shall be entrusted to the heads of children's home, orphanages, no, or other similar institution. The law considers, nakita ninyo, yung natural love of a parent to outweigh that of the grandparents, such that only when the parent present is shown to be unfit or unsuitable, may the grandparents exercise substitute parental authority. What about the special parental authority? It is the parental authority granted by law to certain persons, entities, or institutions in view of their special relation to children under their supervision. No? It is limited and is present only when the child is under their supervision, no? Instruction, or custody. So it can coexist with the parent's parental authority. So sino tong nag-exercise ng special parental authority? The school administrators, school teachers, individual, entity, or institution engaged in childcare. Anong scope ng special parental authority na ito? It applies to all authorized activities, whether inside or outside the premises of the school, entity, or institution. So what is the let's proceed now to the grounds, no? Grounds for termination of parental authority. What are the grounds? Pwedeng permanent or temporary, no? Sa permanent, death of parents, emancipation of the child, or death of the child. In case, by the way, in case of temporary termination of parental authority may be revived through a court judgment. Yan. So, adoption of the child, temporary lang yan. Appointment of guardian, judicial declaration of abandonment, final judgment, divesting the parents of the parental authority, incapacity of the parent, judicial declaration of absence or incapacity. How about the grounds for suspension of parental authority? If it gives corrupting orders, counsel or example, if they treat the child with excessive harshness and cruelty, or if they subjects or allow the child to be subjected to acts of lasciviousness, conviction of crime with penalty of civil interdiction, culpable negligence of parents exercising parental authority, or the child is compelled to beg. Take note that if the person exercising parental authority has subjected the child or allowed him to be subjected to sexual abuse, he or she shall be permanently deprived of parental authority. If the ground for suspension of parental authority is civil interdiction, then the suspension is automatic as to his reinstatement. Okay? And for last slide for the persons and family relations is the suspension. How is suspension of parental authority is revoked, no? And how it is revived? The suspension may be revoked, no? And the parental authority is revived by filing a case for the purpose, or in the same proceeding, if the court finds that the cause therefore had ceased, had ceased, and will not be repeated anymore. All right. So We will continue our discussion. This time, we will discuss property. Okay, so to continue our discussions on the civil law, we now discuss property. So first is the classification of property. No, it is classified as we know. No, when as regards to mobility, immovable and immovable, movable and immovable property. Okay, so what is an immovable property? Madalas sumabas sa bar exams that it includes land, building, roads, construction of all kinds, adhere to the soil, the trees, plants, growing fruits, while they are still attached to the land or form an integral part of the immovable. Everything attached to an immovable, no, in a fixed manner in such a way that it cannot be separated therefrom without breaking the material or deterioration of the object. And then the statues, reliefs, paintings, or other objects for use or ornamentation, which is placed in the buildings or on lands by the owner, no? By the owner of the immovable, in such a manner that it reveals the intention to attach them permanently, no? To this to the tenement, and then the machinery, receptacles, instruments, or implements intended by the owner of the tenement, now for an industry or works which may be carried on in a building or on a place of land or on that piece of land which tend directly to meet the needs of the said industry or works. And then we have animal houses, pigeon houses, beehives, fish ponds, breeding places of similar nature in case their owner again has placed them or preserved them with the intention to have them permanently attached to the land. And then fertilizer actually used on a piece of land, the mines, quarries, and slag dams while they are still forming the bed, no, and waters, the docks and structures, though floating, no, if they are intended by their nature and object to remain at a fixed place in that river, lake, or coast, and then contracts for public works and servitudes and other real rights over immovable property. How about movable properties? Movable properties, those are susceptible of appropriation but which are not included in Article 415 in the enumeration. And they are also the real property which by any special provision of law considers as personality, such as growing crops, no? And also the forces of nature which are brought under the control of science. What else? In general, all things which can be transported from one place to another without impairment, no, of the real property to which they are fixed. And then the obligations and actions which have for their object movables or demandable sums, shares of stocks of agricultural, commercial, and industrial entities, although they have real estate. How about the test to determine, no, whether a property is a movable property? What are these tests? The test of exclusion, no, everything not included in Article 415 by reason of a special law, no, immovable by nature but movable per purposes of the special law. And test of mobility, if it is capable of being carried from one place to another but without injuring the property to which they are attached. Okay, let's proceed now to ownership. Ownership, When we speak of ownership, it is a juridical relation of a person over the thing, by virtue of which said person has the exclusive power or authority to receive all the benefits and advantages arising from said thing, save those which are restricted by law, no, or subject to such limitations, recognizing the rights of others. What are the kinds of ownership? We have full ownership, which we have naked ownership, we have sole ownership, we have co-ownership. And then, how about the characteristics? Characteristics of ownership, we have ownership is elastic. Na? It is elastic because the powers may be reduced and thereafter automatically recovered upon the cessation of the limiting rights. It is also general in such a way that it has the right to make use of all the possibilities or utility of the thing owned, except those attached, no, to other real rights existing thereon. It is also exclusive. There may be two or more owners, but there is only one ownership. It is also independent in such a way that other rights are not necessary for its existence. And it is also perpetual in such a way that the ownership lasts long as the thing exists. It cannot be extinguished by non-user but only by adverse possession. So what about the attributes of ownership? What are the attributes of ownership? The right to enjoy, the right to the fruits. Diba? If you own the thing, you have the right even to abuse the thing, the right to dispose, the right to recover, the right to accessories, the right to enclose. You may enclose it, fence your property. You may also exclude anyone from going there in your property. And of course, you have that right to possess the same. What about the remedies to recover the possession of property? Eto, pag personal property, you will file a replevin in court. That is recovering a personal property. How about in real property? We have this action interdictal, no? Under which nandun na ang forcible entry and unlawful detainer. And what else aside from action interdictal? Action publiciana and then action reivindicatoria. So what is the remedy to recover possession of movable property? As we said earlier, it's replevin. That is the remedy when the complaint prays for the recovery of the possession of personal property. So, take note that a property validly deposited in a custodia legis, no, this cannot be a subject of a replevin suit. How about recovery or possession of immovable property? Starting with action interdictal. Action interdictal, in contrast with action reivindicatoria and action publiciana, it is a summary action to recover physical or material possession only. And it must be brought within 1 year from the time the cause of action arises. So how may, sabi natin, kasama dyan si forcible at saka si unlawful detainer. How may an unlawful detainer suit prosper? The defendant, there should be a reason why that defendant possess the same, such as, for example, there is an existing contract of lease, and after demanding the defendant to vacate the same, it becomes now illegal. No, if he continuously possessing the same, either for failure to vacate the same, or if there is because the contract has expired already, or there is a violation that he committed in the provisions of the said contract, and he remains in possession, no? Thus depriving now the plaintiff the enjoyment of that property. So, importante yung demand to pay. Na? Demand to pay and vacate. Dapat end. na? And the suit again must be brought within 1 year from the last demand. So ang reckoning point is the demand letter. Kaya if you have previously sent a demand letter in the past, that should not have any, no, that should not have been mentioned anymore if it is more than a year, so that it will have another new cause of action. No? Do not have any reference to the previous demand letters if it is already more than 1 year. Otherwise, you will lose the jurisdiction to have this be tried under a summary procedure. How about action publicana? Action publicana, it is an ordinary civil proceedings to recover the right of possession. Kasi natapos na yung 1 year, eto na, ipa-file mo, action publicana. Except of course, no, kung pumasok pa sa within 1 year, such as yung forcible entry and unlawful detainer case. So what is involved here is clearly the what is again involved here is not possession de facto but possession de jure. Na? So it refers to an ejectment suit filed after a year, no, from the cause of action. So it because again of withholding the possession of the property. How about action reivindicatoria? This is an action to recover real property, this time based on ownership. So the object here is the recovery of the dominion over the property as owner. So take note that where the facts averred in the complaint reveals that the action is neither one of forcible entry or unlawful detainer, but essentially involves a boundary dispute, for example, then what should be resolved is an action reivindicatoria. In short, yung allegation sa complaint is very material. Because that determines jurisdiction. So what are the requisites of this action reivindicatoria? Importante that if you will be filing this complaint, the identity of the property must be alleged. It must be proven. And the title to the property of the plaintiff. So what is an we leave now the this by the way, yung forcible entry, unlike in unlawful detainer, demand letter is not material there. But still, the 1 year period must be complied with in order to fall as a summary proceeding case. All right. We proceed now to discuss accession. What is an accession? Accession is the right pertaining to the owner of a thing over everything which is produced thereby or which is incorporated or attached thereto, either naturally or artificially. So what is that right of accession? That right of ownership out of which an owner of a thing has over the products of said thing, as well as to all things inseparably attached or incorporated thereto, either naturally or artificially. Is it a mode of acquiring ownership? No, because it is not among the enumerations. It is not among the modes of enumerations of acquiring ownership. What are the different kinds of accession? We have accession discrete, under which are the NIC, natural, industrial, civil. We have action continua, under which is with regard to immovable property, the accession industrial, building, planting, sowing. We have accession natural, under which is alluvium and avulsion. Then we have the change in the river beds and also the formation of islands. So let's discuss as regards to movable property, by the way, we have adjunction or conjunction. And then we have commixtion or confusion. We have specification. As regards to the fruits naman, let's now discuss the rule on the owner's right of accession with respect to what is produced. Yun na nga yung fruits. What is produced in this property. To the owner, it belongs the natural fruits, the industrial fruits, the civil fruits. What is the obligation of the owner who receives the fruit from a third person? He who receives the fruits, at meron siyang obligation to pay the expenses made by third person in their production, gathering, and preservation. In short, yung mga necessary expenses incurred. He has to reimburse the same, no? Take note that only such that are manifest or born are considered as natural, or industrial fruits. Okay. How about the rule on ownership regarding accession industrial? As a general rule, the owner of the land is the owner of whatever is built, planted, or sown on that land, including the improvements or repairs made therefrom. By way of exceptions, no, when the doer is in good faith, the rule is modified. Or the improvements on the land of one of the spouses at the expense of the conjugal partnership, this will belong to the partnership or to the spouse who owns the land, depending on which of the two properties has a higher value, pursuant to Article 120 of the Family Code. Let's proceed now. Accession natural, no, or natural. We have alluvium or alluvion. Ano? This is the gradual, yun ang keyword there gradual deposit of sediment by natural action. So gradual, natural, na, the original identity of the deposit being lost. So it states to the owners of the land under Article 457, to the owners of the land adjoining the banks of the rivers belongs the accretion, no, which they gradually receive from the effects of the current of the waters. All right. Let's proceed now to quieting of title. Pag sinabi natin quieting of title, what do we mean by that? Uh, by the way, it is bounded. It is grounded on. It is grounded. I mean, on equity. It is a proceeding in equity, the purpose of which is to the declaration of the invalidity of a claim on a title or the invalidity of an interest in property adverse to that of the plaintiff. And thereafter to free the plaintiff and all those claiming rights under him from any hostile claim thereon. So ano yung nature niyan ng action to quiet the title? It's quasi in rem. Na? It's quasi in rem. It's an action concerning real property where judgment therein is enforceable only against the defeated party, no, and is prevailed. So only real properties, by the way, can be a subject of an action for quieting the title. Hindi ho ito nag-a-apply sa personal property, sa real property lang. So ano ang requirement for an action to quiet the title? It may be brought to remove the cloud or to quiet the title, by the way, to real property or any interest therein. So ito yung mga requisites that must be present. Number one, the plaintiff must have a legal or equitable title, or interest in the real property which is the subject matter of the action. And there must be a cloud on such title. Kailangan ba yung plaintiff in possession of the property? No. The plaintiff need not be in possession of the property. So what else? Such cloud must be due to some instrument, record, claim, encumbrance, or proceeding, which is apparently valid or effective, but is in truth and in fact invalid, ineffective, voidable, or unenforceable, and is prejudicial to the plaintiff's title. And the plaintiff must return to the defendant all benefits that he may have received from the latter, or reimburse him for expenses that may have redounded to his benefit. So anong purpose of an action to remove cloud on the title? It is intended to procure the cancellation or delivery or release of an instrument, encumbrance, or claim constituting a claim on plaintiff's title. Di ba? Kasi may doubt no? Because the plaintiff is claiming ownership thereof, and somebody now, no, is claiming right over this property, so that must be removed. No? This can be used because of that claim, no, that can injure, no, or vex the owner of the property in the enjoyment, no, in his enjoyment of his property. So ano yung prescriptive period in filing or bringing an action to quiet title? If the plaintiff is in possession of the property, imprescriptible yan. No? Imprescriptible yung action niya to quiet title. If he's not in possession naman, ordinary 10 years, 30 years extraordinary. No? So it prescribes within that period for filing an action publicana or action reimbidicatoria. Okay. Kanina na hindi pala natin na-discuss yung avulsion. Ano? Okay. Yung avulsion, by the way, this may be defined as the accretion which takes place or lake segregates from an estate or its bank a known portion of land and transfer it to another estate. So yung kanina sabi natin gradual, ito naman ang keyword dito sudden. Ha? So sudden. What is the rule with regard to avulsion? Whenever the current of a river creek segregates from an estate or a bank, known portion, uh, and transfer it to another estate, the owner of the land to which the segregate portion belong retains the ownership, provided that he removes the same within 2 years. Ngayon, when it comes to the current, no, yung mga trees, by the way, trees uprooted and carried away by the current of the rivers, it belongs to the owner of the land upon which they may be cast, no, if the owners do not claim them within 6 months. If such owners claim them, then they shall pay the expenses in gathering or putting them in a safe place. So yung distinction between alluvion and avulsion, no? Take note of those. Yan. So take note of their distinction. Yung gradual si alluvion, si avulsion is sudden. Na? Yung accretion, it cannot be identified. Si avulsion, it can be identified. All right. As regards to the changes in the course of the rivers, if the river changed, no, its course by natural causes, it opens a new bed through a private estate. This bed shall become a public dominion. Ang requisites dyan, kinakailangan natural change. Natural change in the course of the waters of the river. Otherwise, the bed may be the subject of the state grant. And the change must be abrupt. It must be sudden. The change must be permanent. And there must be abandonment by the owner of the bed. These rules, by the way, do not apply to temporary overflowing of the river. Ano? So why? Because this hindi pwedeng temporary lang eh. The change must be permanent. All right. We have PD 1067, by the way, na? PD 1067. This is the Water Code of the Philippines. In fact, most of the provisions there pertaining to easement in the water, nako-cover na ni PD 1067 or the Water Code of the Philippines. In short, under the Water Code of the Philippines, the government or the riparian owner may return the river back to the original bed. Yung kaninang pinag-usapan natin. No? However, when it comes to the rule on abandoned riverbed, it does not apply if the river simply dries up because there are no persons whose lands are occupied by the waters of the river. Okay? Let's proceed now to discuss co-ownership. What is co-ownership? There is co-ownership whenever the ownership of an undivided thing or right belongs to different persons. No? So may undivided interest ka dito. So it is the right of common dominion which two or more persons have an ideal part of the thing which is not physically divided. So by the very nature of co-ownership, a co-owner cannot point to any specific portion of the property owned in common as his own. Kasi hindi mo alam unidentified, alin doong part. Ikaw ba nasa gawing kanan? Are you on the left side? Are you on in the front or at the back? In short, you have your share, but it is still an undivided interest. So your share remains ideal and intangible. Okay? So what is the share of the co-owners in the benefits and charges arising from the co-ownership? Since can I have a short break muna, na? So we could make it big. No? Okay. So to continue no our discussion, and sorry for the interruption no, due to technical issue. Let's proceed now no our discussion on co-ownership. We mentioned earlier that there is co-ownership whenever the ownership of the upon undivided thing no or right belongs to different persons. Okay, so what is the share of the co-owners in the benefits and charges arising from the co-ownership? It shall be proportional. No? It shall be proportional to the respective interest, and any stipulation in a contract to the contrary shall be void. No? Consequently, in order to determine the share of the co-owners in the benefits and charges, we must first determine the respective interest in the co-ownership. So yung interest, these are presumed equal unless the contrary is proved. What about the general rights of each co-owner as to the thing owned in common? One is to use the thing. Use it according to the purpose that is intended to such thing, provided that it is without prejudice to the interest of the co-ownership and without preventing the use of other co-owners. Take note that as regards to the without the second one, without preventing the use of other co-owners, uh, and I'm sorry, the purpose, not the purpose. We have to take note that the purpose of the co-ownership may be changed by an agreement, express or implied. Second, the general one of the general rights also of each owner as to the thing common is to share in the benefits in proportion to his interests, provided the charges are borne in the same proportion. So if there is a contrary stipulation, that is again void. Huh? Hence, benefits cannot be stipulated upon by the co-owners. So take note of that. What else? Each co-owner also may bring an action for ejectment. So hindi kinakailangan nilang mag-SPA pa, no? If the others or if others would not be joining in the action for the in the complaint for ejectment, no need. The action for ejectment that we are referring to covers forcible entry, unlawful detainer, action publicana, quieting of title, action reivindicatoria, and replevin. Okay? And then also another right is to compel other co-owners to contribute to expenses for the preservation of the thing and to payment of taxes. Also to oppose to any act of alteration, even if beneficial to the co-owners. And also to protect against acts of majority which are prejudicial to the minority. Also to exercise legal redemption, to ask for partition, and also the right to exempt himself from obligation of paying necessary expenses and taxes by renouncing his share in the pro indiviso interest, no, but cannot be made if prejudicial to the co-ownership. And also the right to make repairs for preservation of things. This can be made at will of one co-owner, no? Receive reimbursement therefrom. The notice of necessity of such repairs, by the way, it must be given to co-owners if practicable. And also the right to full ownership of his part uh, and the fruits. No? Also, he has the right to alienate, to assign or mortgage his own part, except personal rights, like the right to use, no? And habitation. And also the right to exercise preemption, the right to be adjudicated, no, the thing, subject to the right of others to be indemnified, and also the right to share in the proceeds of sale of the thing if the thing is indivisible and they cannot agree that it be allotted to one of them. Okay, what about the distinctions between the right to property owned in common and full ownership over the ideal share? So let's see the right to property owned in common. There are two restrictions, by the way, in the enjoyment of this right. One is that the co-ownership shall not be injured, and that the exercise shall not prevent the other co-owners from using the property according to their own rights. Take note that each co-owner is granted the right to use the property owned in common, now for the purpose for which it is intended. Then, full ownership, no? Full ownership over his or her ideal share. A co-owner, by the way, has full ownership of his share o yung tinatawag na undivided interest niya, no? And also in the fruits and benefits arising therefrom. So being the full owner of that, he may alienate, assign, or mortgage it. He can also substitute another person in the enjoyment of his share, except only when the personal rights are involved. What about the co-owner's right to use the property in common? Meron ba siyang right to use the property in common? As we said earlier, each co-owner may use the thing owned in common, provided that he does so in accordance with the purpose for which it is intended, no? And in such a way as not to injure the interest of the co-ownership, as we mentioned earlier, or prevent the other co-owners from using it according to their rights. If one co-owner alone occupies, for instance, the co-owned house, the entire house, without opposition from the other co-owners, there is no lease agreement. The other co-owners, of course, with that, cannot demand payment of the rent. What about the expenses? Yung bang what are the expenses which the co-owners can be compelled to contribute? Only necessary expenses. As regards to useful, ornamental expenses or luxury expenses, they are excluded. May a co-owner exercise the right of redemption of co-owner's share? Yes. The shares of all or any other co-owner, if sold to a third person, may be redeemed by a co-owner. If two or more co-owners want to redeem, na, they may do so in proportion to the shares that they respectively have. Yung right of legal redemption, this cannot be exercised when there is no co-ownership. So once the property is subdivided, distributed among the co-owners, the community ceases to exist. There is no more reason to sustain any right of legal redemption. What about the effect of redemption by a co-owner? What is the effect of redemption? Nagiging kanya na ba yung property? Yung redemption of the whole property by a co-owner, it does not vest in him the sole ownership over the said property. Yung redemption within the period prescribed by law will inure to the benefit of all na co-owners. So it will not put an end to their existing co-ownership. How about in case of alienation? May a co-owner alienate the shares of his other co-owners? Can he do that? No. While a co-owner has the right to freely sell and dispose of his undivided interest, as a co-owner, no, nevertheless, he cannot alienate the share of his other co-owners. Eh, paano kung binenta niya lahat? What if he sold the entire property? No? The disposition that this co-owner made as regards to the entire property, this will only affect his share pro indiviso. And the transferee gets only what corresponds to his grantor share in the partition of the property owned in common. So in short, pertaining only to the share of this co-owner. What about the status of the sale by a co-owner of the whole co-owned property? A sale of the entire property by one co-owner without the consent of the other co-owners, that is valid. Ha? Yung sale mismo, ha? Yung sale. However, as we said earlier, it only affects the interest or share niya ni co-owner sa undivided property of the co-owner who owns the same, na? Who sold the same. So anong remedy? Na ang remedy nung bumili is an action for partition. Under Rule 69 of the revised Rules of Court, no? That is to divide the common property. What's the effect of partition? It confers upon the co-owner exclusive title over the property adjudicated to him. And the possession of the co-owner over the property adjudicated to him, it shall be deemed exclusive. No? Exclusive for the period during which the co-possession lasted. In other words, it is deemed continuous. What about the obligations of co-owners upon partition? One, he has the obligation of accounting, yung mutual accounting for benefits received, fruits and other benefits, mutual reimbursement for expenses, the indemnity for damages caused by reason of negligence or fraud, and the reciprocal warranty for defects of title and quality of the portion assigned to the other co-owner. What about the rule in case the co-owners cannot agree in the partition? Then, if that is the case and it involves a real property, an action for partition against the co-owner or other co-owners may be filed. And in case of personality and actual partition, if that could not be made, it may be sold. No? And the proceeds be divided among the owners after deducting the necessary expenses under the discretion of the court. What about the rule in case the co-owners cannot agree as to the partition of a thing which is essentially indivisible? Ayun yung binabanggit natin kanina. Pwedeng ibenta, it may be sold, and the proceeds distributed, or it can be allotted to one of the co-owners who shall indemnify the other or others. All right. So let's now discuss the acts of co-ownership, no? The required uh, number. Like in the case of ejectment, as we mentioned earlier, any of the co-owners may file such an action. When it comes to administration, majority of the co-owners shall decide. When it comes to improvements of the property, of the co-owned property, majority of the co-owners shall take part. And when it comes to alteration, all of them, all of the co-owners must agree. And when it comes to preservation, any of the co-owners can do so. Let's proceed now to discuss possession. Ano? What's the role in possession in the concept of an owner? If a person possesses and concepto de dueño, no? So he may eventually become the owner by prescription. And a possessor merely in the concept of holder, he cannot acquire property by acquisitive prescription. Why? Because this is because in succession, it is far from being adverse. It recognizes the right of ownership in others. So one cannot recognize the right of another and at the same time claim adverse possession, now which can ripen to ownership through acquisitive prescription. So for prescription to set in, the possession must be adverse, public, and to the exclusion of all. So who can exercise possession in the concept of a holder? Lessees. Lessees or those merely permitted to occupy, the trustees, the anticritic creditors. Now, when it comes to trustees, by the way, it includes parents over the properties of their minor children or insane children, and or the husband and wife over each other's properties, as long as the marriage lasts. And even if there be a separation of property which had been agreed upon, no, in a marriage settlement or by a judicial decree. Aside from them, the agents, attorneys, no, regarding their clients' properties, depositaries, and co-owners, no, unless the co-ownership is clearly repudiated by an equivocal acts communicated to the other co-owners. How about the rights of a possessor as to the necessary expenses? Ito yung possessor in the concept of owner. Let's distinguish, no? If in good faith and also if in bad faith siya. If in good faith, he's entitled to refund or retain the premises until paid. If he is in bad faith, then he's entitled only to a refund. He has no right of retention by way of penalty. Yung right of removal ng necessary expenses, there is no right of removal of necessary expenses whether in good faith or bad faith, no? And the necessary expenses, by the way, it affects the existence or substance of the property itself. How about the rights of a possessor in the concept of owner as to the useful expenses? If in good faith, he has the right of reimbursement, no? At the owner's option yan, yung plus value, no? And then also the right of retention until he is paid, the right of removal unless the owner or lawful possessor exercises the option in number one. So, itong right of removal, he can do so provided that there is no substantial damage or injury is caused to the principal that would reduce its value. Take note that the possessor in good faith is entitled to both the fruits and the expenses, no? Necessary or useful. Hence, they do not compensate each other. If in bad faith naman siya, the possessor in bad faith is not entitled to any right regarding the useful expenses. So as to the removal of the useful expenses or improvements introduced by the possessor, only a possessor in good faith is allowed to remove the useful improvements that he had introduced, provided that the useful improvements can be removed without damage to the principal thing. What about expenses to pure luxury, no? Yung reimbursement. Pwede ba yung i-reimburse? Yung expenses for pure luxury or pleasure, it shall not be refunded to the possessor in good faith. But he may remove the ornament within which he has embellished the principal thing if it suffers no injury. And if his successors in the possession does not prefer, no, to refund the amount that he expended. All right. Let's proceed now to the rule. The rights of a possessor in the concept of honor as to luxurious or ornamental expenses. If he is in good faith, wala nga siyang right to refund, no, or retention, pero he can remove it so long as there is no substantial injury caused. And the owner has the option to allow the possessor to remove or to retain for himself the ornament by refunding the amount spent. If he is in bad faith naman, in general, no right of refund yan, no? Or retention, but can remove if no substantial injury again is caused. May option uli si owner either to allow the possessor to remove or retain for himself the ornament. I-refund niya yung value at the time the owner enters into possession. How about the right of the possessor as to the fruits? If he is in good faith, then he can gather or severed or harvest fruits, no, as his own. And then pending, these are his own. As regards to the pending or ungathered fruits, this is pro rata between the possessor and the owner of the expenses, and then the net harvest as well as the charges. If he's in bad faith, then as to the gathered fruits, he must return the value of the fruits already received as well as the value of the fruits which the owner or legitimate possessor could have received with due care, no, or diligence, minus the necessary expenses. As to the pending or ungathered fruits, no rights at all, not even to expenses for cultivation, because by accession, all should belong to the owner without indemnity. So yung cost of litigation over the property, it shall be borne by every possessor. What about the rule on liability for loss or deterioration? A possessor in good faith shall not be liable for the deterioration or loss of the thing possessed except in cases in which it is proved that he has acted with fraudulent intent or negligence after the judicial summons. Yung si possessor in bad faith naman, it shall be liable for the deterioration or loss in every case, even if caused by fortuitous event. So, I made a table, no, as to the distinctions, no, between one who is in good faith and another one who is in bad faith, as to the fruits received, as to the pending fruits, as to the necessary expenses, as to the pending, as to the useful expenses that we just discussed, as to ornamental expenses, and as to liability, no, in case of deterioration or loss. Let's proceed now to discuss the remedy of the possessor in good faith for all unpaid necessary and useful expenses that he made. What is his remedy? So a possessor in good faith has the right of retention of the property until he has been fully reimbursed for all the necessary and useful expenses made by him on the property. Its object is to guarantee the reimbursement for the expenses, such as those for the preservation of the property or what we refer as necessary expenses, or Also for the useful expenses, no? It permits the actual possessor to remain in possession while he has not been reimbursed by the person who defeated him in the possession for those necessary expenses and useful improvements that he had made over the thing. All right. So this is the summary of recovery or non-recovery principle. The owner now may recover without reimbursement from the possessor in bad faith or from the possessor in good faith if the owner had lost the property or had been unlawfully deprived of it, the acquisition being from a private person. And the owner naman may recover it but should reimbursed if the possessor acquired the object in good faith at a public sale or auction, because the publicity attendant to a public place should have been sufficient warning for the owner to come forward and claim the property. Okay. This is the owner naman cannot recover even if he offers to reimburse, whether or not the owner had lost or been unlawfully deprived, if the possessor had acquired it in good faith by purchase from a merchant store or in fairs, markets in accordance with the Code of Commerce and special laws. If, second, situation, if the owner is by his own conduct precluded from denying the seller's authority to sell under the principle of estoppel. And also, if the possessor had obtained the goods because he was an innocent purchaser for value and holder of a negotiable document of title to the goods. Suppose a recently stolen property is found in possession of A. Can we presume that A is the thief? Yes. It is a disputable presumption that a person who is found in possession of a thing taken in the by reason of taken unlawfully taken, no, that is already a disputable one. Now, disputable because it can be disputed. It is true that one who possesses a movable acquired in good faith has what is called as an equivalent of title. But this is destroyed when it is proved that said movable belongs to somebody else who has lost it, no, or has been unlawfully deprived of its possession. So, in order to contest the title of the possessor in good faith, what should the true owner do? Present mo yung sufficient proof of the identity of the object and that he had either lost it or had been illegally deprived of it. So that would be an indispensable requirement, no, as to prove, no, your right over the thing. So without that proof, no, of such loss or illegal deprivation, yung present holder cannot be put on his defense. Even if as a possessor, he has no actual proprietary title to the movable property, no, in question. All right. We proceed now to usufruct. What are the rights of the usufructuary as to the thing and its fruits? One is to receive the fruits of the property in usufruct and half of the hidden treasure that he accidentally finds on the property. And also, by the way, the usufructuary is entitled to the natural, industrial, and civil fruits that will accrue during the existence of the usufruct. No? And also to enjoy any increase which the thing in usufruct may acquire through accession. And also to retain the thing until it is reimbursed for advances for extraordinary expenses and taxes on the capital, to make such improvements or expenses on the property that he may deem proper, no, and to remove the improvements provided no damage is caused to the property. Also, to collect reimbursements from the owner for indispensable extraordinary repairs, taxes on the capital that he advanced, and damages caused to him. And also to remove improvements made by him if the same will not injure the property. And also to personally enjoy the thing or lease it to another, generally for the same or shorter period as the usufruct. And also to set off the improvements that he may have made on the property against any damage to the same. As regards to the thing itself, take note that the usufructuary may lease the thing to another. Kaya nakalagay dyan, to personally enjoy the thing or lease it to another, even without the consent of the owner. Okay? Let's proceed now to discuss the obligations of usufructuary. Ano yung mga obligations niya? He has these obligations. Before the usufruct, he has the obligations. During the usufruct, may obligations din siya. And after the usufruct, he has the obligations. So let's start with before the usufruct. The usufructuary has the obligation to make an inventory and also to give security as a general rule. During the usufruct, he should take care of the property. He should replace the young of animals that die or are lost or become prey when the usufruct is constituted. No? He should make ordinary repairs. He should notify the owner of urgent extraordinary repairs. He should permit work or improvements by the naked owner, which is not prejudicial to the usufruct, and also to pay the annual taxes and charges on the fruits. On the fruits, not the thing itself, on the fruits. And also to pay interest on taxes on capital paid by the naked owner. Pay debts when the usufruct is constituted on the whole patrimony. To secure the naked owners or court's approval to collect credits in certain cases. And also to notify the owner of any prejudicial acts committed by third persons and to pay for court expenses and costs. After the usufruct, may obligasyon uli siya. Kasi terminated na yung usufruct, right? So he should now return the thing in usufruct to the naked owner unless there is a right of retention. He should pay the legal interest for the time that the usufruct lasts. And he should indemnify the naked owner for any losses due to his negligence or of his transfer risk. Take note that the usufructuary may be liable for the damages sustained by the naked owner on account of fraud committed by him or through his negligence. But by way of exception, the usufructuary is not liable for deterioration due to wear and tear and fortuitous event. Okay. How about the modes of extinguishing usufruct? What are the modes of extinguishing usufruct? We have acquisitive prescription, and we have total loss of the thing, the death of the usufructuary. But before that, as regards to acquisitive prescription, take note that the use by a third person, not the non-use of the usufructuary, yun, the use ng third person yan. Mere non-use of the usufructuary does not terminate the usufruct. Okay? By way of exception, unless it is also a renunciation. And then, second, total loss of the thing. So if the loss of the thing is only partial, then the usufruct continues with the remaining part. Okay? Third, death of the usufructuary. As a general rule, the death of the usufructuary generally ends the usufruct because, again, the usufruct is constituted essentially as a lifetime benefit for the usufructuary or in consideration of the person. By way of exceptions, in case of multiple usufructs, in case there is a period fixed, and also in case the contrary intention clearly appears. Also, aside from death of the usufructuary, termination ng right of the person constituting the usufruct. It would also be a mode of extinguishing the usufruct. Also, the expiration of the period or fulfillment of a resolutory condition. So, if the usufructuary is a juridical person, by the way, the term should not exceed 50 years. What else? Another mode of extinguishing the usufruct is renunciation by the usufructuary. So, it partakes the nature of a condonation or donation. It can be made expressly or impliedly as long as done clearly. So, if done expressly, then it must conform with the forms of donation. Renunciation of usufructuary's rights, by the way, is not an assignment of right. It is really an abandonment by the usufructuary of his right and does not require the consent of the naked owner, but it is subject to the rights of creditors. So there can be a partial waiver except if it is a universal usufruct. Okay? So aside from that merger of the usufruct and ownership in the same person who becomes an absolute owner thereof. And there are other causes of termination of usufruct. We have the annulment of title, or annulment of act, rescission, expropriation, mutual withdrawal, legal causes for terminating legal usufruct, or abandonment or dissolution of the juridical entity granted with usufruct before the lapse of the period. What is this abnormal usufruct on consumable thing, or what we term as quasi usufruct? This is another instance of abnormal usufruct, and is sometimes referred nga as quasi usufruct because the form and substance is not really preserved. Na? This is really a simple loan. It has been included, however, in the title of usufruct because of universal usufruct. Both non-consumable and consumable properties are included. So, uh, it this abnormal usufruct or consumable things is again a simple loan. Na? It's really a simple loan. What are the characteristics of let's proceed now to discuss let's leave usufruct and proceed now to discuss easements. What are the characteristics of easements? We have as characteristics it as a right limited by the needs of the dominant owner or estate without possession. It is inseparable from the estate to which it is attached. It cannot be alienated independently of the estate. It cannot consist in the doing of an act unless the act is accessory in relation to a real easement. It involves two neighboring estates, the dominant and the servant estate. And also, it's a limitation on the servant owner's right of ownership. It is also indivisible. Na? It is not affected by the division of the estate between two or more persons. Also, it is enjoyed over another immovable, never on one's own property. And it's a real right, but will affect third persons only when it is registered. Let's discuss its classifications, kinds. It is enjoyed over another immovable, never on one's own property, as we discussed. So under this, we have real right and personal. So yung real right, as we mentioned earlier, it will only affect third person once it is registered. No? And then as to manner of exercise, we have continuous, we have discontinuous. So for acquisitive prescription, the easement of aqueduct and easement of light and view are considered continuous. As to whether their existence naman is indicated, we have apparent. No? So yung easement of aqueduct is always apparent whether or not it can be seen. Na? So it is apparent and also non-apparent. As to the right given, the right to partially use the servant estate, the right to get specific materials or objects from the servant estate, the right to participate in ownership, and the right to impede or prevent the neighboring estate from performing a specific act of ownership. Then, as to sourced, we have legal, we have voluntary, and we have mixed. As to, okay, and then as to the duty of the servant estate, we have positive and we have negative. How about the modes of acquiring easement? By title. By title, under this is continuous non-apparent easements, discontinuous apparent easements, and discontinuous non-apparent easements. Also, aside from by title, by prescription of 10 years. Yung prescription, it runs, irrespective of good faith or bad faith of the possessor and whether or not he has a just title. So the only requirement is adverse possession. Take note that only continuous and apparent easements can be acquired by prescription. Also, by deed of recognition, by final judgment, by apparent sign established by the owner of the two adjoining estates, except or unless at the time of the ownership of the two estates it is divided. And then there are contrary stipulations or the sign is removed before the execution of the deed. What about the modes of extinguishing easement? By merger. By merger, by non-user for 10 years with respect to discontinuous easements, by when either or both of the estates fall in such condition that the easement cannot be used, and by the expiration of the term or fulfillment of the condition, by the renunciation of the owner of the dominant estate, and by redemption, agreed upon between the owners of the dominant and servient estates. Okay. There are different modes of acquiring ownership. We have occupation, we have law, we have donation, we have tradition, we have intellectual creation, we have prescription, we have succession, right? Okay. So, let's start with occupation. Ano yung mga requisites of occupation? Kailangan may seizure of a thing, which must be corporeal, personal property, and susceptible of appropriation by nature. The thing must be without an owner, and that there must be an intention to appropriate. Pag sinabi mo kasing occupation, it's the acquisition of ownership by seizing corporeal thing that have no owner na? Made with the intention of acquiring them and accomplished according to legal rules. How about donation? Donation is an act of pure liberality, whereby a person disposes gratuitously of a thing or right in favor of another who accepts it. There are different kinds of donations. We have according to motive, simple, remunatory of the first kind, remunatory on the second kind. We have model donations, onerous donations. And then as to perfection or extinguishment, we have pure with a condition, with a term. And then according to effectivity, we have inter vivos, mortis causa, and then donation propter nuptias. Okay. So, yung sa simple, simple donation, ang purpose niyan pure liberality. And the form is same to that form in donation. If it is a remuneratory under the first kind, its purpose is to reward past merits, services rendered by the donee to the donor, provided that the same do not constitute a demandable debt. And then as to form, it is same as that of the forms in donation. And then as to the remuneratory of the second kind, the purpose is consideration for future services, or the donor imposes certain conditions, limitations, or charges upon the donee whose value is inferior to the donation given. The form is same as that of contracts if it is onerous. And if it is gratuitous, is same as that of the form of donations. So if it is an onerous naman, The purpose is to impose upon a donee a reciprocal obligations, burdens, charges, or services that are equal or greater in value to that of the donation. Ang form yan is same as that of a contract. So ano yung mga requisites of donation? We have as requisites the capacity of the donor to make the donation, and that he must have this donative intent or animus donandi. Talagang gusto niyang i-donate. And there must be delivery in certain cases. And that the donee must have this acceptance, no, or consent to the donation during the lifetime of the donor and of the donee. If it is a donation inter vivos, whereas in the case of donation mortis causa, the acceptance must be made after the donor's death because it will partake as a will. Okay. How about the essential requisites or features of elements of a true donation? Ano yung mga essential features niyan? May alienation niyan of property by the donor during his lifetime, which is accepted. Irrevocable, na? Irrevocability by the donor. The donative intent. And the consequent diminution of assets of the donor. What is the extent to which the donor may donate the property? It may comprehend all the present property of the donor or part thereof, provided that he reserves, in full ownership or in usufruct, sufficient means for the support of himself and all of the relatives who, at the time of the acceptance of the donation, are by law entitled to be supported by the donor. Pwede bang i-donate yung future properties? Unlike in donation propter nuptias, sa ordinary donation, hindi pwede. This cannot be a subject of donation. Donation cannot comprehend future properties. Because pag sinabi mong future property, it means anything which the donor cannot dispose, cannot deliver, di ba? At the time of the donation. So future inheritance or the inchoate right to inherit, this cannot be donated because it is a future property. And then, ano yung mga limitation on the amount that cannot be donated? The limitation, by the way, applies only to simple, remunerative, and then modal donations, but not to onerous donations because these are governed by the law on contracts. Okay. So, again, ang limitation on the amount that can be donated. If the donor has forced heirs, he cannot give or receive by donation more than what he can give, what he can receive by will. If the donor has no forced heirs, donation may include all present property provided that he reserves in full ownership or in usufruct. No? The amount necessary to support him, those relatives entitled to support from him, and then also the property sufficient to pay the donor's debt contracted prior to the donation. So ano yung effect if the donor violates the requirement for reservation? A donation where the donor did not or did not reserve property or assets for himself in full ownership or in usufruct sufficient for his support and all his relatives, na, is not void. That is not void. It is merely reductible, no, or reducible. So pwede lang siyang i-reduce to the extent that that he can support himself and his relatives, and that this may not be prejudiced or be impaired. Okay. We discuss now donation inter vivos. What are the limitations imposed by law in making donation inter vivos? One is that the donor must reserve sufficient means for his support, as we mentioned earlier, and for his relatives that are entitled to be supported by him. And that donation cannot comprehend future property, as we mentioned again also, except donations between future husband and wife. And that no person may give by way of donation more than what he may give by will. So ang distinctions naman between donation inter vivos and mortis causa is the fact that inter vivos takes effect during the lifetime of the donor, independently of his death. Huh? While in mortis causa, it takes effect upon donor's death. And as to the cause or consideration, sa inter vivos, it is pure generosity. Whereas in mortis causa, it contemplates of the donor's death but without intention to dispose the thing in case of survival. And also in inter vivos, it is valid if the donor survives, no, the donee. Whereas in mortis causa, it is void if the donor survives. And in inter vivos, it is generally irrevocable, except for grounds provided for by law. So mortis causa, it is always revocable at any time and for any reason before the donor's death. And also, ang inter vivos, dapat kino-comply niya yung formalities of the donations. Sa mortis causa, formalities ng will. And inter vivos, the acceptance must be during the donor's lifetime. Kay mortis causa, after, no? After death ni donor. And also, as regards to the property conveyed to the donee, yung property sa inter vivos completely conveyed yan to the donee. Kay mortis causa, yung property is retained by the donor while he is still alive. Okay. So, yung sa formalities ng donation, just take note that as regards to movable property, with simultaneous delivery of property donated, pagka ang halaga is 5,000 or less, pwedeng oral lang yan. O pwede ring written. But what is important is that this can be orally made. But if it is more than 5,000, kinakailangan it must be written in a public or written document. And if there is no simultaneous delivery naman, the donation and acceptance must be written in a public or private instrument. Na? Regardless of the value, the donation, the statute of regardless of value, the donation is unenforceable. And then, as regards to immovable property, it must be in a public instrument specifying the property donated, the burdens assumed by the donee, and that the acceptance may be made doon sa same instrument or pwedeng in another instrument notified to the donor or a donor in an authentic form and noted in both bids. Otherwise, the donation is void without the acceptance. Another thing is the grounds for revocation of donation. Ano ba yung grounds under these grounds for revocation of the donation? Under Article 760, the birth of a donor's child or children, no? Whether legitimate, legitimated, or illegitimate after the donation, even though born after his death. And then the appearance of a donor's child is another thing also, no? Who is missing and thought to be dead already by the donor. Or the subsequent adoption by the donor of a minor child. And also under Article 764 this time, when the donee fails to comply with any of the conditions which the donor imposed upon the donee. And also under Article 765, by reason of ingratitude, if the donee should commit some offense against the person, the owner, or the property of the donor, or of his wife or children under his parental authority, if the donee imputes to the donor any criminal offense involving moral or any act involving moral turpitude, even though he should prove it, unless the crime or act has been committed against the donee himself, his wife or children under his authority, or if he unduly refuses team support when the donee is legally or morally bound to give support to the donor. So the list for the grounds of the revocation by reason of ingratitude, this is exclusive. What about the grounds for reduction lang? Reduction of donation. Same grounds dyan sa revocation. The donation shall be reduced insofar as it exceeds the portion that may be freely disposed of by will, taking into account the whole estate of the donor at the time of the birth, appearance, or adoption of a child. Yung bang revocation, automatic ba yan? O yung reduction? Hindi yan automatic. That is not automatic. The emergence of the circumstances enumerated in Article 760, when it comes to revocation, it do not automatically revoke or reduce the donation. The revocation or reduction is authorized only if the amount or the value of the property donated exceeds the disposable free portion. So, for purposes of prescription of action, what is the rule? In case of concurrence of two or more grounds for revocation or reduction. So, in the event that two or more causes are present, the earliest among them shall be the starting point in the reckoning of the period of prescription of the action. How about the effects? Anong effects ng revocation or reduction in donation? But it now provides obligations of the donee upon the revocation or reduction of donation, such as he has to return the thing or the object of the donation. If the property had already been alienated and could not be recovered anymore, its value shall be paid to the donor. The value shall be the price of the property estimated at the time of the perfection of the donation. And then if the property had been mortgaged, the donor may pay the mortgage obligations subject to reimbursement by the donee. Okay. And then the donee also has the obligation to return the fruits. So if due to non-compliance with any condition imposed on the donation, the fruits acquired after non-compliance, these shall be returned. And if due to causes is stated under Article 760, ingratitude or inofficious donations, the fruits acquired from the time the complaint is filed shall be returned. Okay? So uh, the this is all for property. Thank you. Let's pause for a break.